Good morning, everyone. Thanks for joining us on our gavel-to-gavel coverage of the Caitlyn Kaufman murder trial. We expect things about to begin on this rare Saturday session. Any moment now, I believe the judge may be coming into the courtroom. There she is. And the jury should be coming in. Let's listen in on this day 6 of the trial. The defense chance now, possibly closing arguments and deliberations and a verdict later. Let's listen in.
Thank you. I forget that. You can be seated, sir. Thank you. All right. The court has filed an order as it relates to Mr. Morris's testimony, and the court stands on that order. We need to address the test. I did not do a written order as it relates to Dr. Warren's testimony. I do believe that Dr. Warren, his qualifications are sufficient. I think that what was at issue was shooting incident reconstruction based upon Dr. Warren's testimony as it relates to his training in that particular area, the fact that he has been qualified on multiple occasions in that particular area, and that he's even conducted training in that particular area. The court finds that he is qualified to testify. I know that the state submitted that he was not qualified in that area, but if the court found that he was, that his testimony should be limited based on the fact that he has not done any testing of, I'm going to probably paraphrase a little bit, but of moving vehicles with an individual inside. I don't think that that's sufficient for me to limit his testimony, but I do think that it's obviously something that he can be cross-examined on. So I do find that Dr. Warren is qualified in those areas to present expert testimony. All right. Now, did y'all review the jury charge?
Yes.
Okay. So request for special instruction. Let me see if I can pull it up on here really quickly. I didn't print it off. What did you have, Mr. Munkabo? Like you were trying to tell me something?
The jury charges something, well, the reference to James Edward Count, AKA James Edward Willard, the jury knows him as James Cameron, Your Honor. I don't think that's appropriate to put AKA as an alias, Your Honor.
Is that what's on the indictment? Hold on, let me get my computer's not. Let me see. Oh yeah, I got a copy of it. That's okay. Make a copy of this and give it to Debbie so that she can have it as we. You don't have an extra copy of this by chance, do you? If not, that's fine. Okay, give that to, you sure? Yeah. Give that to Ms. Franklin because she'll probably need to be listening in as we discuss this. Okay. I mean, Mr. Munkabo, that's what's on the indictment. I mean, they'll have it.
We can just stipulate to it then, Judge. I don't need to.
Okay. Well, it's on the indictment. I'll let it, I mean, it's already been read to the jury. Stipulate to what?
I mean, Your Honor, they don't, if that's James Cowan is James Edward Lillard. I just don't know what this might tend to confuse. And Your Honor, I just don't think that it's appropriate.
Does the state care to be heard?
Judge, I think it was a little bit too late. We're not gonna make an issue out of that, or
Yeah, I don't think anybody's made an issue, and the indictment was read, and if I recall, it was read, the alias was read verbatim, and it's on the indictment. So your objection is noted, Mr. Munkabo.
Thank you.
You're welcome. All right, now, Ms. Sims, you want to talk about your requests?
Yes, ma'am. Request one, consistent with our motion in limine about referring to Mr. Hill by his name instead of the defendant. Request one just asks to change the language and the instruction to Mr. Hill, Mr. Cowan, Mr. Hill, and/or Mr. Cowan, whatever is appropriate grammatically, to replace the word defendant. I think the only exception would be that first line. The indictment in this case charges the defendants James Edward Cowan and Devontae Lewis Hill. I think that obviously that makes sense for that sentence, but after that, just using their names as opposed to the defendant would be our request.
What says the state?
Your Honor, the case is the state of Tennessee versus these two individuals. The state is the plaintiff, they are the defendants. The pattern charge references that, and there is absolutely no prejudice whatsoever or any reason to deviate and put their names in every single solitary time for you to find a defendant guilty of this offense. Page 4. For you to find
And it says a
a
defendant.
defendant, yes. So find Mr. Cowan and, do we do and or? Because I think it doesn't say that whenever the singular is used, it can mean the plural.
And in the motion in limine, the court, I did not grant the motion in limine. I did strongly encourage the parties to refer to Mr. Cowan and Mr. Hill by their names, but I did not find a legal basis to order them to be referred to by their names, because they are a party to this lawsuit. And so while that request is well taken, I'm going to deny the request as to number one. I don't find that there's any prejudicial effect because they are a party to this lawsuit. Okay, your next one is, I need to refer to page 16.
Yes, ma'am.
All right.
So starting on the first paragraph on page 16, and this request is just because there were
Multiple transcripts.
multiple recordings, multiple transcripts, multiple people involved, and so this request essentially is, in our opinion, is clarifying the language. So part A, the videotape recorded statement you heard, we would propose changing that to you heard and saw video and audio recorded statements. These statements were edited, so just acknowledging that there was more than one statement.
Okay.
And then in part B says the tape contains statements made by police officers. Since we have, again, multiple statements,
Yeah.
multiple recorded statements, the same principle applies as to the statements made by other people on the jail calls as it does to the police officers, that those words are not being offered for the truth of the matter, that they should not be considered as evidence by the jury, and they are only to provide context. And that was part of our conversation about the jail call redactions. Frankly, we talked a lot about that. And so just trying to make the language in that paragraph broad enough so that the jury understands it's not just the police officers in the interview that the jury can't consider their statements, but also the other callers that are not Mr. Hill
Okay.
on the jail calls. They can be considered for context.
Of course, the state is about to say, well, what about adoptive admissions?
Well, I'm sure the state's gonna say that.
All right, I'm already anticipating that. Go ahead.
What about adoptive admissions, Your Honor?
I mean, I think the court could add an additional sentence in there, something to the effect of, you know, if you believe based on the context that Mr. Hill has adopted what the other person says, you can consider that. But, I mean, we're kind of getting in weeds here. I mean, all we're trying, I mean.
I think, I see what, I definitely see the point with there being the two, because that paragraph is kind of limiting it to just the police interview. It does not take into consideration the jail calls. I see that point. But the question then becomes, with regards to those third-party statements, does the language stay in about how the jury is to consider the statements by the third-party individuals? So that's your issue.
That's our issue, and I would say that that's not any different than what happens in a police interview and what's in this pattern jury instruction language. You know, if the police officer says, you know, you were at the MAPCO when it was robbed, and the person says yes, I mean, that would be an adopted admission. You know, I think a jury's not confused by that with the language of the pattern instruction.
All right, what says the state? What does the state? I mean, she makes a valid point in terms of we have two different statements that we're dealing with. We're dealing with Mr. Hill's police interview, and we're also dealing with his jail call. So I do think we need to draw that distinction, but I think the question is going to become more relative to the jail calls, because the state made a point in our pretrial motions as it relates to the adoptive admission in those jail calls. So what says the state, and how do you propose we rectify the language in this paragraph?
Remember, I'm just suggesting this as a suggestion to consider. In the interview as well, there were, because we don't have the full recording, a lot of it is the detective repeating back to him what he said and him saying, yeah. So I don't know if anything that's said might not work both ways, because you need to consider both statements and the totality of the meaning of that statement.
And I think that court instruction, as it stands, but for clarifying that there are multiple recordings, does that. I mean, the court's instruction says already, these statements of these witnesses are admissible only as they provide meaning to the statements made by the individual identified.
Yeah, I mean,
I think that covers it.
well, I was going to say, I think that if we just add language that distinguishes the jail call and the jail calls and the police interview, I think the rest of it, I mean, because this comes straight from the TPI.
Right.
The statements are not admitted for the truth of the matter asserted by these officers or other people. These statements of these witnesses, they're not witnesses,
Yeah, we would suggest these people, but I mean.
are admissible only as they provide meaning to the statements made by the individual identified as the defendant. I mean, I think that the language as is, other than drawing the distinction between the two different forms of recordings, is appropriate. Does the state have any final thoughts on that? I mean, this language comes straight from the TPI.
Yes, and speaking of the TPI, 42.11, I think probably, unless I'm missing it somewhere in here.
Let me see. Hold on. I don't know if this is my most updated version.
Is that admission against
Yes.
interest? That's actually, we are actually asking to be instructed on.
I was gonna say, that should go in there somewhere.
Agreed.
What is it? I'm sorry.
It's the
42.
admission against interest.
What number was it?
42.11, 42.1.
Yeah, that's part.
40. Oh, wait a minute. That.
Yes.
Well,
At least mine is the 26th edition.
Tell Debbie I need I got the 21st edition. It's a little old.
The language,
I mean, I doubt that that's been changed. It's probably the same thing. Evidence has been. Okay. So 4211, not 4211A, because I saw 4211A. You're looking at 4211, correct? All right, now, so both parties agree that that comes in.
I think using because it's either confession or admission against interest, and we say the admission against interest, like using the language for admission against interest, not confession.
Okay, let me write this down for Ms. Franklin. Okay, now, but I'm still, and I guess that you're suggesting that that goes in following this language?
Wherever the court thinks is appropriate.
I don't even know if it's not, I will admit, I was busy working on the order last night, so I did not look at the jury instruction. I trusted that you all would look at it and come to me with your recommendations, so I'm assuming that that is not in there.
It is not.
Okay, all right.
I would think perhaps that would come first, then you explain about how to use the tape.
Okay, so this comes before page 16. All right, now,
So that was actually our number 4 request. You want to go back to number 3?
yeah,
That is a request to
4219.
include the pattern jury instruction for inferences before page 17. So page 17 is the inference regarding concealing or destroying evidence. So we just request the general inferences instruction.
okay. Does the state care to be heard? So
I
that's
think that's fine.
4219 inferences, and you're suggesting that that comes before the language regarding destruction of evidence?
Yes.
Okay.
Although I suppose if the admission against interest is an inference as well, I mean, it could come before that, but
I think really anywhere.
yeah.
All right, so we've already addressed number 4. Number 5.
Number 5, with the court's order on Mr. Morris, we would amend our request to number 5 just to include.
Yeah, and we were waiting to do that. Ms. Franklin was waiting on my order. Excuse me, on my ruling on that issue, so he'll be, and you're suggesting that it's labeled expert in the field of firearm and tool mark identification and shooting incident reconstruction?
Yes.
Okay, that will come in. And then number 6.
And then our request on number 6 is just the,
22.
that last paragraph on page 22, if you find from the proof that a witness has been convicted of some prior crime or crimes, I would suggest moving that to the end of the impeachment section, which is on the prior page. I think it's more appropriate to include that.
Before the impeachment?
Right, instead of after the court's instruction about whether or not
Okay,
a defendant is testified.
wait a minute, let's see.
State would read that, Your Honor.
Okay.
Whether it goes, the last sentence of the first paragraph or.
So we need to move on, I'm looking at page 20, well, wait a minute. Okay, so the final paragraph on page 22 reads, if you find from the proof, ellipses, and you're suggesting that that be moved to page 21 before the paragraph when a witness is thus, no.
I would say just the last sentence, where the sentence, the first paragraph, it ends, has willfully testified falsely.
Okay.
And then just, if you find from the proof, put that sentence there.
Okay, so move if you find from the proof, da, da, da. That's currently on page 22, correct?
Yes, sir.
So move that to so it would read, however, Immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. If you find from the proof, ellipses. Is that, okay, all right. So that covers, Mr. Munkable, other than your initial request, did you have anything else?
No, Your Honor.
Okay, so then the state has submitted a request for jury instruction. Oh, is that not in there? I thought we talked about criminal responsibility. Was that not in there?
Not that particular verbiage.
What page is it on? Is it in there? Is anything in there?
It's criminal responsibility, Your Honor, but it's just that first piece of the definition, and it doesn't have
What-
that secondary.
What, you know what page it's on?
Yeah, it's
Page
Hmm?
page 3.
I'm not sitting working. So the second paragraph on page 3 is, are you suggesting that this language be added in that second paragraph?
Yes, Your Honor.
All right, what says the defense?
I think that's probably related to Mr. Cowan.
What about,
No, Your Honor.
you don't have any objection?
No, Your Honor.
Okay, so we'll add this language that's there. Let me see. I'm gonna put a Post-it note on this so that I'm not writing on it. Add on current page 3. Page 3, at the end of the second paragraph. Is that what you're suggesting?
Yes, Your Honor.
Second paragraph. All right. I think we got everything. I'm going to pass this back to Ms. Franklin for her to finalize that. I think she has a copy of this, so she just needs that right there. And, oh, she probably needs, wait a minute, which one is the updated one? This one is the updated one. She probably needs this back. There you go. All right. That's to be filed. All right, is there anything else? All right, well, we can, is everybody road trip compliant this morning? Because I'm going to, the station wagon is leaving the rest stop. Or I guess now it's minivan is leaving the rest stop. Anybody? What?
I need to do a moment here.
Oh, thank you. Yes, I forgot about that. Oh, thank you. All right. Yes, so, Mr. Cowan, if you'll please stand. And I have my moment voir dire in here. Raise your right hand, please.
Do you solemnly swear or affirm that the testimony you give to be the truth, the whole truth, and nothing but the truth to help you God?
Okay.
Right.
Mr. Munkabo, do you wish to voir dire Mr. Cowan, or do you wish for me to?
You can, Your Honor.
Mr. Cowan, do you understand that you have the right to not testify, and that if you choose to not testify, the jury could not draw any inferences from your decision to not testify? And in other words, you have the right to testify if you want to. You have the right to not testify. And if you chose to not testify, I would instruct the jury that they could not hold that against you. Do you understand that? Okay. Do you understand that that by having the right to testify, and if you wish to exercise that right, no one could prevent you from testifying. Do you understand that? That means that your decision, to testify or to not testify is a decision for you to make. Nobody can force you either way. Do you understand that? Now, have you had an opportunity to consult with Mr. Munkabo as to whether you wish to testify? And in your discussions with Mr. Munkabo, has he talked with you about the advantages and the disadvantages of you presenting testimony? And was he able to answer any questions that you may have had on the issue? Okay. I don't want to get into any of your discussions with Mr. Munkabo because that's privileged communications between you and Mr. Munkabo, okay? But I need to make sure that you clearly understand that this is your decision and it's a choice for you to make. Do you clearly understand that?
Yes, ma'am.
Okay. After considering your right as it relates to presenting testimony in this case, and after consulting with Mr. Munkabo, what is your decision as it relates to testifying in this case?
I'm not going to.
You're not going to testify?
No, ma'am.
Okay. If you'll sign that moment off. Did you wish to add additional questions, Mr.
No,
Munkabo?
just to reiterate what you said, I've discussed in length with Mr. Cowan the disadvantages and advantages of testifying, and so I think that this is a free and a free decision, freely and voluntarily that he's waiving his right to testify.
All right, thank you. All right. Is Mr. Hill at a point at this moment to voir dire the court on this issue, and so that you all know, I know that Mr. Chapin has done a trial with me. I tend to do moment oaths both ways. I kind of do the reverse moment just to kind of clear the record. Is Mr. Hill ready to do that now, or do you all need time to address this?
We're ready.
Okay. Mr. Hill, I'm sorry, thank you. Yes, please swear me in. Thank
Raise
you.
your right hand, Mr. Hill. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
Okay. Mr. Hill, kind of the similar discussion, but I want to talk with you now as it relates to presenting testimony in this case. Do you understand that you have the right to present testimony in this case? Do you understand that?
Yes, ma'am.
And you also have the right to not present testimony. If you do not have to present testimony, and if you made the decision to not present testimony, I would instruct the jury that they cannot draw any inferences from that, draw any conclusions based upon your decision to not testify. Do you understand that?
Yes, ma'am.
And do you also understand that the decision to testify is a decision for you to make? That is your choice. Do you understand that?
Yes, ma'am.
Do you also understand that nobody can force you either way? Nobody can force you to testify. Nobody can force you to not testify. Do you understand that?
Yes, ma'am.
And have you had an opportunity to consult with your lawyers with regards to your decision to testify?
Yes, ma'am.
And during your conversations with them, were they able to explain to you the advantages and the disadvantages of testifying?
Yes, ma'am.
Were they able to answer any questions that you may have had regarding the advantages and disadvantages of testifying?
Yes, ma'am.
Okay. And after consulting with your lawyers, what is your decision as it relates to presenting testimony?
I'm still going to
You're going to
testify.
testify. Okay. All right. Now, that is just the waiver to testify, so I don't think he has to sign it, but I just wanted to make sure that we got that on the record. All right. Thank you. Okay. Now, is there anything else? All right. All right, line them up. Okay, we may all be seated. Let the record reflect that on this Saturday, January 28th, the jury hearing this trial are present in the courtroom. Good morning, ladies and gentlemen, and thank y'all for giving us your Saturday morning. I know that this has been a long week, and probably weren't anticipating being down here on a Saturday, but thank you so much for being here. I hope you all were able to rest well and adhere to the court's instructions regarding any discussions about the case. Okay. Yesterday, as we concluded, the state had rested its case. Is the defense ready to present any evidence? Mr. Munkabo?
Yeah, no evidence, Your Honor.
Okay, this is the defense ready to present evidence on behalf of Mr. Hill?
Yes, Your Honor.
Okay.
First witness is Devontae Hill.
Mr. Hill?
That's his voice, sir.
Right hand. Do you solemnly swear or affirm that the testimony you give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Introduce yourself to the jury and spell your first name for the court reporter.
My name is Devontae Hill. First name Devaunte. Last name Hill Hi.
How old are you?
23.
23. Did you fire the shots that killed Caitlyn Kaufman?
Yes, I did.
Who was driving the car?
Mr. Cow,
What kind of car were you in?
Cadillac SUV.
Did Mr. Cowan have anything to do with the shooting? Let's back up a little bit, okay? Where were you living for 2020?
1500 Port.
Who else lived there with you?
My mom.
Okay. And did you stay somewhere else on?
With my
Where was that?
in Antioch.
So you kind of split time?
Yes.
Okay. Where were you in sometime in the morning on these?
Antioch with my girl and kid.
Okay. And did at some point that day you meet up with Mr. Cowan?
Yes, later on in the apartments.
Okay. Can you just kind of explain that for the jury and tell them a little about that?
So I just, sometime when I left from my girl house, I went to the apartments to just chill and hang out with friends like I usually do. And then while we were there, I decided to get in touch with Mr. Cowan to see what he had going on, because his birthday was like a few days before.
Okay. And he's just a friend of yours?
He's actually my cousin.
Okay. How, in December 2020, how long had you known him?
Few years.
Okay. And you eventually met up with Mr. Cowan?
Yeah.
What, at some point that you leave?
Yes, we went to her.
Okay, explain that for the jury, because they've seen a cell phone map just to show you his Cowan's device going to Hermitage. So why did you go to Hermitage and who was there?
So we decided to go to Hermitage to meet with my brother, because like me and my brother, ever since I had my kids, we decided to build our relationship basically on the sake of the kids.
So your brother lives in Hermitage?
Yes.
Okay, and did you go out there with Mr. Cowan in the Cadillac?
Yes.
What were y'all doing out there?
We were chilling in my brother's house. We was smoking, just talking, checking on each other kids, seeing how everybody was doing. That was pretty much it.
Okay. When you say smoking marijuana?
Yes.
Okay. What time of day is this, if you remember?
It was, if it wasn't dark, it was getting dark.
Okay. At some point, do you leave?
Yes.
Okay. Where did you go? Where did you leave to?
We was headed to we was chilling. Calvin, he had to pick his girlfriend up, so we decided like we had to head to her.
Okay. And did When you left your apartment, did you know that was part of the trip?
Then,
Okay. So you left Hermitage.
yes.
Did you know where you were going?
I didn't know where she worked at.
Okay. Do you know, were you talking about Demonisha Carter?
Yes.
Okay. You didn't know where she worked at all?
No.
Okay. So you knew you were going to get her, but you didn't know where?
Yeah.
Okay. Well, then just walk the jury through that. Where did you go?
So, like, when we left the apartments, like, in the midst of leaving, cause my brother stayed in Hermitage in some apartments. In the midst of leaving that, like, we was smoking on the way there. So, as we was riding to go get his girl, we had the windows down to air out the car to let the smoke out. And, like, in the midst of that, we was cut off, like, on the interstate.
Were you doing some other drugs in the car?
Yes, before we left, I did a little cocaine and popped a Xanax.
Okay. And then you said something happened, right?
Yes,
Where was that?
on the interstate.
Okay. Right before it happened?
Uh,
The question is, when's the first time that you saw this vehicle?
like right before it happened.
Okay. Let's talk about the trip all the way into Nashville. Was that normal?
What's to go?
Yeah.
Yeah, it was just a normal day.
Okay. And let's break this down because this is the most important point. What happened?
While we was riding, I can't say, but I know like that she came from the left of us because we had just like basically got on the interstate. So she came from the left and just like cut us off. And when Calvin hit the brakes, it startled me, and like I just very quick and irrational, and just I remember picking up the gun and then firing the first shot, but I couldn't recall how many shots at that moment that I had fired.
What were you doing? What were you thinking?
I wasn't thinking the right way. I should have been thinking.
Why did you get so mad?
That's something I couldn't explain. It just was a reaction.
You knew somebody was driving the car, right?
Yes, I did.
Did you see somebody? Did you look at somebody?
No, I wasn't even.
Do you not that's dangerous?
Like now, well, I should have known that it was dangerous, but like I said, I wasn't thinking at the time.
What were you trying to do?
I can tell you what I was trying to do.
What happened right after? What did you do? What did y'all do?
Right after it happened, Calvin asked me like, he told me I was bullshitting, excuse my language, and asked me like, why did I do that? What was I thinking? And like I told him like, shit, I wasn't thinking, I just reacted. And then we went to pick his girlfriend up.
And what do you remember where that was? Do you remember where you got off the interstate or how quickly you got off the interstate? Can you explain that?
I know we got off like on the west end exit or somewhere in that area, but I couldn't tell you exactly like where we went to.
How far after the shooting did you get off the interstate?
It was the first exit.
What is your mindset like after that?
At that time, it was still like full of like rage a little bit, like, so I wasn't as calm as I should have been.
Did y'all talk to Miss Carter?
No.
Was that a specific decision?
It wasn't. We just like after he asked me those questions and I gave him my answer, I guess we both was just sitting there thinking, like marinating on it.
when you fired that shot, did you see the vehicle anymore?
No, I didn't.
You didn't stop.
No.
What did you think had happened?
At the time, I wasn't thinking anything, but I should have known that I could have hurt someone or somebody could have been injured.
So, explain to the jury what happened after you picked up Miss Carter.
So after we picked Miss Carter up, Calvin drops me back off in the apartments in 1500 Porter Road. And like I go in the house and just, I'm sitting there, it's still on my mind. So eventually I end up searching Nashville shootings because I know I've done something.
And that leads me to my next question. The jury saw a bunch of phone data yesterday, including a bunch of information from your phone.
Yeah.
And just kind of describe that for the jury. Were you using your phone? That's your phone, isn't it?
Yes.
And was it you that was using your phone?
Yes.
Okay. I think you just mentioned you knew you did something, obviously.
Yes.
So kind of talk to the jury about that. What is your mindset like? What are you doing? Why are you searching that?
I was thinking like I was constantly searching because I was worried that like eventually I was worried like that I could have like I realized that I could have done something wrong. I could have hurt someone, killed someone, or anything. So I was basically in a panic trying to see like if anything can happen.
Okay. At what point did you realize you actually had killed another human being?
It was hours later.
Okay. Where were you and what were you doing?
When I actually seen it, I was actually in the car with someone, and they had seen like a social media post of like it just like a news clip of a nurse being killed. So when I seen that, I quit talking to the people I was with, and I just left and went in the house, and the panic came back, and I was searching again.
Okay. And does that coincide with the article that was on your phone that the jury saw yesterday?
Yes.
So you accessed that when you went back inside.
Yes.
And then what are you doing? What's your mindset like now? Now you know you killed another person.
So now it's like I'm very worried now. So in the midst of all them days, like I'm doing more drugs than I usually do. I'm avoiding people. I'm staying away from everybody. I'm avoiding everybody. Like I'm social distance now. I ain't really just communicating with people.
You mean you stayed at your house a lot?
Yeah, in the house.
In the house?
Yeah.
Okay. Let's talk about, you tried to get rid of the gun. You did get rid of the gun, didn't you?
Yes, eventually, but I actually tried to get rid of it before I even knew anyone was hurt because I knew I have done something and like I didn't want that gun anymore.
We may have missed this, but I think it's an important point. Where was the gun in the car?
But when I hopped in the car, since it wasn't my car and I wasn't driving, I just took the gun off of my hip because it would have been like uncomfortable sitting with a gun in my hip, like in the car for that ride.
So where was it?
I had just set it in my lap, not specifically.
Let's go back to getting rid of the gun now. Now you know you've killed somebody and you've got a murder weapon.
Yeah.
When did you ultimately give it to Mr. Odom?
I seen him in the apartments on December 4th, the day after the shooting. And like I get in the car with him, it's just me and him, no one's around. The stuff that he said about December 6th was totally a lie. I seen him December 4th, and like me and him, I get in his car, we doing drugs, getting high, and like somehow it was still on my chest, like bugging me that I done this, so I decided to like open up and show him like I did this, I messed up, this wasn't supposed to happen, she cut us off. And he offered to get rid of the gun. I never told him to get rid of it or anything.
Okay, let's kind of walk that back a little bit because he told the jury something different yesterday, didn't he?
Yes.
Okay. How do you know for sure it was December the 4th?
Because like I know for sure because the next day after I got the gun from him, I started searching for like extended clips for that gun. I know I wouldn't search for extended clips for a gun that I didn't have before time.
You're saying that something in your phone was, you were searching for a magazine for a different type of gun?
Yes, and that showed on December 5th.
Okay. Let's talk a little bit about your relationship with Mr. Odom. Why did you decide to tell that guy?
Because he was a person that I didn't decide to just tell him. It was a spur of the moment because I was feeling down. But he was a person that I grew up with. Like he was just a person I grew up with, a friend that I thought I could trust.
Okay. And you just said that he offered to get rid of the gun. So this whole thing about what he told the jury is you gave him the gun, and then sometime later you were like, oh, by the way, that gun is used in a murder.
Yes, that was a lie.
That never happened.
No.
Okay. What you're saying is that you gave him, well, you told him to take it.
Yes, he told me, like, after I showed him the article, I was like, I need to get rid of this gun. He said, just give it to me. I got somebody I can drop it off to, and they'll never know. I'll give you his gun, and, like, basically the switch will be cool.
Let's talk about this party. I mean, maybe it looks like that you didn't care.
I did care at the party. If it was to go into full detail, the party, I was actually very high on drugs, basically trying to cope with the situation, which it still wasn't working.
I mean, I think it's obvious you didn't want to get caught.
No, I didn't.
After you gave the murder weapon to Mr. Odom, did you think maybe this is over?
I did, but I still had that gut feeling like that anytime I could be taken away from my kids.
Do you remember the Instagram exchange with Mr. Odom?
Yes, I do.
And the phone call?
Yes.
At the time, did you find it suspicious or no?
At the time, I didn't find it suspicious because my mind wasn't in the right state of mind. I actually really believed that I was helping a friend get out of trouble when he told me that his uncle was tripping and basically thought that he had something to do with it. So I really thought I was helping him stay out of trouble.
The jury heard your interview with the police.
Yes.
I mean, you lied to Detective Dickerson.
Yes.
He gave you a full hour to tell him this.
Yes.
Why didn't you tell him then?
Because at the time I was scared and knew that like this was a serious crime, and I still wasn't just ready to come forth and own up to it.
He presented you with some phone information and then you changed your story.
Yes.
Do you know Raquan Evans?
No.
Explain that whole thing to the jury, please.
That was just a random name that I had made up. It wasn't like anybody specific. I just gave them a random description of a normal person with like a normal black guy with dreads. That's all it was. It wasn't an actual person until he pulled up a picture and said this was him.
So you don't know any Raquan Evans?
No.
Were you surprised when they brought a photo into the room?
Yes.
Okay. But you don't know that guy either?
No.
Okay. They also brought you a photo of Mr. Cowan?
Yes.
And you lied to him?
I did.
Why?
Because that's my friend, also my family. And in times like, in hard times, you protect your friends and family. So that's what I was trying to do. And especially if he didn't commit a crime, he didn't do anything wrong. All he did was drive a car in a situation occurred that he didn't know, that neither one of us knew was going to happen.
What about the jail calls? You're still trying to protect him in those, aren't you?
Yes, basically I am.
And you're trying to give him the heads up. Is that fair?
Yes.
Just 1 second. This is really important, and I want to ask it again. When she cut you off, how much time passed before you started shooting at the car?
I couldn't even say it just happened so quick. It was no longer than 3 to 4 seconds.
Okay. I thought that when I asked you the first time, you said you just gotten on the interstate.
Like when we got on the interstate, we rode for a while, and then somehow the car just came from the left of us, and we smashed on the brakes, and immediately, like soon as we went around, that's like I reacted, like in the midst of us going around the car.
Okay. Do you know where you were?
What you talking about?
Like when it happened, do you even know where you're at when it happened?
No.
Mr. Hill, how long you been in jail?
2 years.
You've had a lot of time to think.
Yes.
What have you thought about? What have you learned?
Objection, Your Honor.
Nick, why is that a question she objected to? What have you learned in the last 2 years in jail?
Well, I figured we would hear an objection sooner. I mean, you know, the jury's not allowed to know, you know, the punishment for these crimes, but they go to great lengths to show that these defendants are not in jail. If you notice, the defendants are already sitting in there, they're in plain clothes, so the jury, you know, they're not flanked with sheriff's department officers. So they go to great lengths to show that these people aren't in custody, and I think getting into the fact he's in jail right now, and I think they're trying to make a sympathy argument potentially, like, you know, you've already been in jail 2 years, you've already been punished some, you've already served some time, kind of maybe potentially a nullification argument, but I'm not quite sure where they were going to go with this.
But I understand why you're saying they try not to bring that up. That's usually because the defense doesn't want it brought up. Here, the defense asked him that question, and they brought up the fact that he's been locked up the last 2 years awaiting trial. So, I mean, that's the defense's call, isn't it?
Well, it's their call. It's, you know.
I mean, I think that helps the prosecution when the jury finds out this guy's already been locked up. He must be bad, right?
Well, he's in jail because he can't make bond.
Well, right, but still, he's been locked up, and I don't believe a bond was ever set for him, by the way. As far as the question of what have you learned, that's when Jan Norman objected. You think?
Well, then I think it could potentially be like sort of a nullification argument or something. You know, I mean, I'm not quite sure what he was going to say. They may have had that discussion already. Who knows what he's going to say about what he's learned.
Does he come off as credible to you?
No, he doesn't necessarily come off as credible because there's too much of, you know, there's statements like, I just had a reaction, I was just still full of rage, I did not think anything. You know, I think what we're missing here for this to make sense is that they were involved in some kind of, he thought it was a rival gang member, okay? And that's why he reacted the way he did, because if this is how he handles being cut off and he doesn't know why he reacted that way, it doesn't resonate with human beings. I don't think it resonates with people, just average people.
Sure. If it does, if you believe him, who this does help is Cowan a bit. I mean,
I think so.
There was the question, and Cowan had nothing to do with the shooting, is basically what he responded to in the question. He admitted Cowan was driving the car, but he says Cowan had nothing to do. It's almost as though Cowan was driving, they got cut off, and he's saying in just a quick reaction, the gun in his lap, he just turned and shot. And Cowan's like, what the heck? So,
well, they're going to cross-examination. They're going to get. You noticed how they just touched on Cowan very briefly and just moved right along. The state's not going to do that in cross. The state's going to say, let's talk about what Mr. Cowan knew. Okay, he didn't go to the cops, did he? No, you didn't go to the cops, right? I mean, that's going to be a heck of a cross-examination. I don't think that Mr. Hill necessarily had anything to lose. But whether or not this helps Mr. Cowan, it looks like the only help so far, the only help that I'm seeing here is for Cowan. Yeah. If there is any help to be had.
Right. And in some ways, if it's possible, I think this could be even more damaging to Hill, especially if you don't believe him to be, truthful here. And in terms of remorse and the like, all we heard was about after the shooting how he just kept doing drugs, and that he was at a party 2 days later, and the party, he's like, well, I really wasn't myself. He still went to a party 2 days later. Is that remorse?
Well, he's also, he wants you to think he's the victim. I'm not hearing any sincere remorse whatsoever. It's more of like, I want to save myself.
Yeah, me. Yeah.
Right. And I mean, this is a young man. He's 23 years old. I mean, God knows he's nervous. I understand that, but still.
Well, and he brings in, how he was concerned about, we find out he's a father and his family, and I'm like, really? I mean, not only that he's charged with this crime, but here he is driving around with a gun and shooting and doing drugs, and he's concerned about his family.
Well, and he's calling, he said in his videotaped interrogation he has never met Mr. Cowan. Now he gets on the stand and says that that's his cousin.
They're cousins.
I don't know if that means play cousin, actual, there's some sort of biological connection, but nonetheless, I mean, there's been a lot of dishonesty that he's had in that videotaped interrogation, of which we couldn't hear all of it, because the audio was poor due to the recording quality.
Right.
But I mean, all those lies, why in the world now do you want the jury to believe you? I mean, how can we trust that what you're telling us now is true?
Exactly. And as you said, cross-examination is going to come up. Now, he said the shooting happened within just 3 or 4 seconds, like instantaneously. She's cut off. Cowan
but she approached him from the left, and so they would have had to go around.
Yeah.
I mean, that's a real big move.
It is, and that would take time. But that Cowan hits the brakes, and then he's got the gun in his lap, which he said was on his hip, but he took it out, put it on his lap because of that, and starts shooting. Sounded like some of the cell phone evidence seemed like it took more time than that. Let's listen in.
They better step up their game on the defense side.
We're going to take a short recess, let you step back, get you some coffee.
All right.
Don't discuss the case among yourselves or anyone.
Okay, so clearly they want to get the jury out of there because they have a whole lot more to discuss and that they can take up in a sidebar.
So we'll be listening in here. They're not leaving the courtroom. It's just things they don't want the jury to hear as they discuss what kind of questions they can continue. Again, if you're just joining us, Devontae Hill, the shooter, the man who killed Caitlyn Kaufman, has taken the stand in his own defense, taking questions right now from defense attorneys. But there will be a cross-examination, and he's trying to tell exactly what happened. Let's listen into what they're discussing here.
You all have started your arguments. Does somebody want to expound a little more and so that the court can get an idea of where?
You sustained their objection on my question. So
right, but I think the issue now is cross-examination.
And again, Your Honor, he said, I should have known, like that somebody would have been hurt. That doesn't open the door for anything else. That's it. Like it was very specific related to this factual scenario.
Okay.
She wants to ask whether he's familiar with firearms. That is a perfectly valid and fair question. Beyond that, it's propensity. It's just, it's not admissible.
Okay, does the state care to be heard?
Yes, Your Honor. This witness has just testified that he should have known that someone could have been seriously injured, saying that he didn't know, that he now knows. but he has shot multiple family members of him before. He has fired a gun at people who were injured. He knew that. And he has just testified as if he has never thought that shooting a gun could injure someone. He's opened the door to that impeachment.
Okay,
He also said, Your Honor, that he wasn't thinking.
okay. All right.
It was very, very fact specific to this case.
All right. I've done some research on the opening the door concept. I'm going to go back and look at some of what I've found in the past. We'll take a short break and let y'all, if y'all find anything else, let me know. Mr. Hill, if you step down and go back over with your attorneys. Thank you, sir.
This is the fascinating part of lawyering for me when it gets into this situation, especially with the defendant testifying, Nick, that old open the door, which you've taught me. If they say certain things that their defense team doesn't want out there, that's opening the door, and Jan Norman and Roger Moore are sitting there, and they pounced. When he talked about saying he fired the gun and he should have known that someone could get hurt, that opens the door because apparently there are priors. We've heard that he had been involved in some shooting incidents involving family members of his own that had been injured.
Previously, he shot his grandmother, I
separate
think.
from this case, yeah, something along those lines. May some of it happen
As a juvenile.
As a juvenile.
That's right.
And that would not be allowed ordinarily. But now for him to say that he didn't really realize someone could get hurt or under those circumstances, Norman is saying that opens the door that, oh, really? You didn't know? How did you not know when you shot some of your old family members and saw? Is that what she's talking about here?
That's exactly what she's talking about. And these are the times that you hate to be the judge, honestly, because,
but this seems clear cut to me. How does the judge not say, yeah, the door's open?
But I don't know that it's necessarily open, because clearly if Judge Dalton rules that the door's open and they ask him about shooting his grandmother, he's getting life. Okay? It's over. It's absolutely over.
He's getting life right now. It's not going to change a darn thing. He's done. He is done. Now, Cowan, different. But you're right, it makes things worse, correct? I mean, and Jan Norman's going for everything she can get, and obviously the defense doesn't want it. If you're sitting here right now watching this, if anyone out there thinks he's getting anything less than first-degree murder, please text me. I mean, come on. With what you just heard here?
Yeah, I mean, I don't think he's helped himself so far. I mean, there's a lot of gaps in his testimony that don't, people have to have a reason to want to, maybe give you a lesser offense. And your testimony, when it has to resonate with people. Like if you hear a song on the radio and you think, I like that song, it's because something about that song, or even a piece of art, it hits you, it touches you, and it resonates with you. And I think that, the human condition, that's indicative of the human condition, in that fact that when he testifies, he's got to say something that is going to resonate, that people could understand, because everyone in there is a human being, okay? And so the fact that, she cut us off, and I don't know why, these blanket statements, I don't know what I was doing, I don't know what I was thinking, I just did it, I just reacted. That doesn't make any sense to anyone, because clearly if that's how you react to being cut off, then you need to be confined, right? I mean, but if you said that, you thought that somebody was trying to kill you as a rival gang member or something, you hate to open the door, but that is what people would say, oh, well, no wonder. Now, that's not going to help him. Either way, he's kind of in a pickle.
It resonates more. I understand what you're saying, exactly.
Because you don't understand. People cut me off all the time. I don't shoot 6 shots down the side and have nothing to say about it.
Yeah.
Nothing to say about it. And then it could very well be viewed as he's just trying to get up here to save Cowan.
Yeah. That's almost what it sounds like. I mean, if you're understanding the difference between these two defendants, Cowan, you heard, chose not to testify on his own behalf, which I think was a wise move, because you see what happens when you do sometimes. Okay, we have Hill doing this right now. He's testifying, and I said all along, for him, he has nothing to lose, okay? Meaning, this may not be helping him, but this is not like, oh, well, he was on the edge, it could go either way, he's testifying. No. His goose was cooked before he even took the stand, and this was a Hail Mary to see maybe if something he says here resonates with the juror. And I think what we're hearing from you, and I agree, is nothing is resonating with the juror right now. And I'm just imagining as I sit here, Caitlyn Kaufman's family and parents sitting in that front row hearing him say this.
Well, I mean, so obviously I forgot about the juvenile convictions as we've sat here for a week, because typically it's a really high burden to get into something like that for impeachment purposes, right? Very high burden. But, you know, when you start talking like that, you know, and the other thing I was concerned about for him testifying was to say that he was sorry, he was remorseful, he was having a hard time dealing with it, or that he's not a violent person, or he doesn't, you know, that's normally not how he responds, right? I mean, clearly, if he gets into that, that would open the door to that Crip's birthday cake.
Yes.
Which would, you know, and other pictures of guns, okay? There were several guns in there, and drugs and the like, so, you know, this is it's a bad spot to be in.
Is there a bearing at all when you think about, you know, DUIs and fatalities in cases like that? Again, if you kill someone when you're drunk behind the wheel, you're not charged with first-degree murder, right?
Right, vehicular homicide.
And I don't know, this is very different, obviously, but, you know, he talks about how he was smoking on the way to pick up the girlfriend with Cowan, probably smoking marijuana, I'm guessing.
Yes.
And also admitted that before they left, he used cocaine and took a Xanax. Clearly, while he was in that vehicle, he was under the influence. He's sitting there with a gun on his lap and then pulls it, and maybe that's why he's trying to make the case that I wasn't thinking the right way. I can't explain it. It was just a reaction. Wasn't really looking. I can't explain it's what he said.
I mean,
he said he was full of rage too.
Well, after the fact, when he got back, but then he talks about how he's trying to essentially reload. When he gets to another place, he's trying to load up another gun, talking about more guns, right? Yeah. I mean, that's...
I think it was after he traded weapons with Odom, he got this new weapon and he's looking to reload and get more ammo for this gun. And then he continues to apparently heavily use drugs in the aftermath. It sounded like he was trying to do that to dull the panic he was feeling. And again, I don't hear any remorse, as you said earlier. It seems all about him. I mean, he's panicking. It seems like he's just thinking about, well, I know at any moment they could catch me, you know. And I'm like, how about something about, oh my gosh, I just took a human life because I did something incredibly stupid, and who was she and why? And we're not hearing any remorse at all.
I mean, we're not hearing any remorse, and I think
maybe that's what they're about to get to. He's not done, but you know.
Yeah, well, and a couple of the things that he said are inconsistent with what Gish testified to. He said that then he saw a news thing, and all of a sudden, then he knew he had, you know, shot and killed somebody. Well, the reality is, before the police department knew, you were Googling it.
Mm-hmm. No, he was Googling, looking, yeah, exactly.
So
he was Googling
you already knew that you shot somebody. I mean, when you shot her, you saw her pull off. You knew that you shot somebody.
Maybe, but again, I think I can also see it where he fires these shots and realizes, I fired 6 shots, I was out of it, I don't know what happened. I'm going to Google to see if I hit someone. I mean, you could see that to see if it pops up.
If I hit someone, I mean, if he shot the tire, I mean, he would know he did. I mean, clearly he knew that there was a high likelihood he shot somebody.
That's true. That's true.
And based upon what the medical examiner said, it's not like Ms. Kaufman continued in her lane at the normal rate of speed. I mean, when that happened, she immediately just, you know, would have drifted over, Nick, and they would have saw that.
Okay, just so we're clear again, as we understand it, as they're driving, and then she came from which direction?
The left, he says.
So she would have been on the left side of them in one of the faster lanes or whatever, a lane over here on I-440, and cuts in front.
Right.
And so all of a sudden, then they maybe go around and pull up next to it.
That's the picture that the evidence is painted.
Okay. Well, he'll be back on the stand. I'm curious.
Now, what do you know about
Well, I'm sorry. Go ahead.
Well, so you know more about this. I mean, what do you know about the juvenile convictions about the grandmother? Do you have a lot of information?
Not a lot. A lot of that was not released. I think there was some reporting early on, and I cannot recall the specifics, but it was juvenile, and there was some kind of shooting incident involving family members and a grandmother. It's basically what you said. Not that anyone was killed, but that there were gunshots fired and someone was injured. And maybe that'll come up. I think that's what Jan Norman's talking about. I'll try to do a search on that and see what some of the stories were we did on that. Not a lot, because again, it was juvenile. I'm not sure how or why that came out. Or maybe that was something that was floating around out there and had not been publicly released necessarily. But yeah, there's a juvenile record. But as you said, Hill doesn't have an adult criminal record.
Because he was never transferred out of juvenile court. He got a slap on the hand down there.
Yeah, so just wanted to ask you on this. The fact that they've gone to Devontae Hill right off the bat, there was some question about Eric Warren and John Morris. There were hearings this morning on that. Morris, it appears she entered a written order, and it doesn't look like he's going to be allowed to testify talking about the cell phone data. Eric Warren was the ballistics expert that was going to testify for the defense. Is it possible he could still be called after Hill, or wouldn't you have saved Hill for last?
No, you save Hill for last. I mean, clearly, you know.
So this might be it.
I think this is it, because everyone agreed that Dr. Warren was a crime scene. He was a crime scene processing expert, because he had worked for the TBI and had been in charge, I think he said, in excess of 20 homicides that they investigated, and he was the lead investigator. He's clearly an expert in firearms identification and firearms ammunition identification, but the shooting reconstruction is where he was trying to go, and they weren't able to, that's where they wanted him to be an expert, and they weren't able to do that.
Okay. Oh, gosh. Rick Casebeer, our executive producer, just brought this to me because I was doing the background check on this story. At age 16, Devontae Hill was arrested after he shot his grandmother, 12-year-old sister, and 6-year-old nephew during an argument about going to school. The teen then tried to shoot his mother, who hid behind a couch to avoid gunfire, police said at the time. That, according here, what Rick handed me, I wasn't able to check on that according to a Tennessean report.
See, and so it begs the question, how do people like that end up back out in the street? If you shot your whole family, I mean, I don't know the circumstances behind it, but I don't know that I need to know the circumstances. I mean, that's why they have transfer hearings, and they try to transfer these individuals to adult court. I mean, think about that. Ms. Kaufman would probably still be here if he got an adult-type punishment.
For that. Now, no one, as far as I can tell, died, but you're right. He shot just about his entire family there. That was at age 16. He was in juvenile court. That's what it was, and that's why he's out. He wasn't transferred to adult court, and I mean, it seems to me the juvenile court judges have a very difficult job in whatever jurisdiction, but only the very serious. And I think it's almost to the point now. I know. It's almost to the point now, unless you kill someone, you're not getting transferred.
Well, but that is serious. I mean, I'm all about the drugs and the assaults and all. Because everyone knows what happens when you transfer a case to adult court with that kind of set of facts. That person's going to the penitentiary forever, right?
Yeah.
Unfortunately, though, and I do want to underscore this, and it's no blame of anybody in the juvenile process, the DA's office or otherwise. The fact remains is that it takes one individual in a situation like this to ruin it for the thousands of other people, children, kids who have actually excelled in the juvenile court system by not having been transferred. But like I said, it just takes one person to kind of ruin the whole thing.
And that's the trick, because the idea is second chances when you're a kid. Hopefully your life is not decided. But if the crime is so disturbing and serious, the very worst have to be transferred. And shooting his grandmother, 12-year-old sister, 6-year-old nephew, and then trying to shoot his mother at age 16, not transferred, and getting out, and here he is. He's murdered Caitlyn Kaufman.
Well, and the other thing too, and gosh, the jury wished they knew that, because if you knew that, I mean, I would be completely finished with the case. Would you not be? If you shot your whole family and now you shot this, I mean, you're out of here.
So what you're saying is, and the judge is deciding this now, if the door's been opened and during cross-examination, Jan Norman can bring this up. As I said, before he took the stand, in my opinion, Devontae Hill was done.
So, I didn't know the facts of that, so I think this is a mistake. Now, knowing those facts, all I knew about was suspended driver's license.
Him taking the stand.
And an assault. Now, knowing those facts, man, that was a disaster.
A disaster, but as I said, he had nothing to lose. He was going down before this happened. In my opinion, he was going down. And now, because of that, again, you made the point earlier, the only one who may benefit from his testimony right now, I think he's damaged himself further, okay, especially if this comes in, is Cowan. And for him saying that, you think the cross, they're really going to go after. Now, tell us more about Cowan. Yeah. Because right now, I'm not sure, based if you believe him, and that Cowan, he says, had nothing to do with it, was just driving, and I shot, and he's like, what? Maybe it's less than first-degree murder for Cowan.
I think if this comes in, that's going to bleed over onto Mr. Cowan, those set of facts about the grandmother, the sister, the mother. I think they're going to be so disgusting with this pair that they're not even going to look at the charge. I'm just telling you the truth. I mean, that's a horrible set of facts, Nick Barris.
Yes.
And, the General Assembly is currently, in session, and so maybe we have Kaufman's law that deals with juvenile transfers in a much more, if you shoot people, more than one person, it's just there's no discretion.
So you think it could bleed over to Cowan, perhaps?
Well, that's a horrible. And so you think who hangs out with somebody that shoots their whole family?
Well, and Cowan is a cousin. He's about the only one that he didn't shoot.
Well,
who knows? I'm just saying. It's like I wonder how. But if there was a lesser included for Cowan, what might it be?
So the judge is going to, instruct on lesser included offenses. There's going to be, obviously the indicted offense is first-degree murder. The next one is second-degree murder, okay? And then they would have facilitation of first-degree murder or facilitation of second-degree murder, whatever you think it is. And so I could see a possibility of maybe Cowan getting a facilitation.
What kind of sentence would that bring?
So that would, it wouldn't be a life sentence. I think, if you get facilitation, that usually grades one offense step lower. Okay, one down, and so facilitation of second would certainly be a good one. for Mr. Cowan, because in that situation, I mean, he's not going to do a lot of time, maybe 12 years or something like that, at 30% or 35%, depending on how many priors that qualify. But facilitation of first degree would still cut that life sentence in half.
Okay, wow, that's a big deal. Listen, what we can do, the judge may take some time with this decision. We'll put the phone number up there, and I'll look as well on Facebook and some of our streaming platforms. If you have questions, give us a call if you'd like, and we'll get your reaction to what you've heard from Hill to this point. Nick, I just wanted to ask you on this. With regard to the attorneys, I think you and I would both agree, these attorneys in the courtroom, I've seen in my day some attorneys, I'm like, why is this person an attorney? Not very good. In this case, I think all the attorneys in the courtroom are quite fine. You know how I feel about the DA's office. Jan Norman and Roger Moore are terrific. As far as the attorneys for Hill, and some people may say, what the heck? I think they've done a good job. I'm like, I don't know who could represent Hill under these circumstances and have any more success or failure, if you will, than these attorneys. I mean, I don't know. I really think Georgia Sims and Jason Chafin, I mean, what more? What haven't they done that they could do? I
agree. Sims and Chafin are very, very good. You're only as good as your client when you're a defense attorney. And the reality is the public defender's office, just like the DA, they don't get to pick their clients, okay? Right. And so these clients come to these lawyers with a set of facts that they creted. And and you're doing the best you can. And so
just keep that in mind. It's not these attorneys.
And Ron Munkebo has been around, I don't want to tell his age, I guess, but he's probably been doing this close to 30 years now, and he did a lot of federal criminal defense, does a lot. I mean, that's pretty much exclusively what he does. And so he's been around, he's seen a lot, and he's no fool either. And actually, to tell you the truth, he's the one that's kind of got some benefit, I think, throughout this trial. On behalf of his client.
He hasn't said a whole lot.
That's right.
Mean, he's known not to push it, just keep my client in the background. We'll see how that comes up with the continued testimony here from Hill, but I just feel it's worth saying that simply because the state, someone else called yesterday, and you weren't here for this, and they were observing that Cowan only has the one attorney. There's some with the public defender's office, they've got 2 or 3, and then the DA's office has Jan Norman, Roger Moore, and his staff, and they're wondering how that's fair sometimes when you see one defendant just has one attorney. The public defender's office has a couple, and the DA's office has 3 or 4. Just how that's set up and how people are paid, Nick, in terms of, is it fair when you see one defendant has one attorney and the other has 2 or 3?
Well, so, clearly in this context, when, the public defender's office, they always, if you qualify, you're appointed a public defender, and of course they cannot represent co-defendants. And so the way it works is that the state of Tennessee is not, if it's not a capital case, they're not going to pay Mr. Munkebo or somebody else for 2 attorneys. Okay. Gotcha. Now they will pay money for experts and the like, and do those things. But and I did want to. Yesterday, someone had placed this on Facebook, yes. and I hate to say, we'll call her Debbie. I don't want to say her last name, but I thought this was very flattering of Ms. Kaufman. It said, Nick, I was in the ICU at St. Thomas for 3 months in 2017, and Caitlyn was my nurse. I did not have her every day, but the days she wasn't my nurse, that day she would always come and visit me. She was the sweetest person I have ever met. Sometime you just take her, let's see here, someone to just take her life of a great person there's no way to live. She was the greatest to know, and the person who did should have known her. This is so sad. So I thought that was nice that even though she wasn't on duty at the hospital, even on her off day, she would come in and visit patients. And so those are great stories. And, we've heard nothing but what a great woman she was.
Yeah, she was apparently, a wonderful nurse, award-winning nurse. And this, keep in mind, happened in the heart of the pandemic. And she was in there working frontline with COVID patients, saving lives. And I'm glad you shared that. That was one of the people that's followed our coverage that brought us that. And I'm glad you read that. Absolutely. Let's take a couple calls. The judge is out right now working on whether a door is open or not, and you heard us explain what that's all about. Let's go to Ann. Ann, good morning. Hi, Ann.
Good morning. First, I spent quite a lot of time last night researching a gentleman whose name I will not mention, but I was very relieved this morning to find out a certain person would not be testifying because, frankly, I couldn't find any qualifications on him. Second, this morning in the jury instructions, some things were brought up. Can you use jury instructions from the judge in an appeal process? And one of you asked, how does someone that has shot 3 family members end up back on the street? That's called their family that got shot did not show up in trial and would not cooperate in the process. And thank you for your coverage. Oh, last but not least, thank you for clarifying on Miss Norman's heritage. As the mother of 3 girls, I'm even more proud of her now than I was Monday, knowing she got to where she is at on her own. I have watched Dick Harpootlian over 50 hours this week, and I have wanted to see him in action for years, and Miss Norman has run circles around him. I cannot believe how unprofessional that gentleman is compared to the attorney that Nashville can claim. On that, I'll let you go, and please keep the phone lines open. It was killing me.
Okay. Thank you, Ann. We'll take as many as we can whenever there's breaks.
So as it pertains to jury instructions in the appeal, absolutely. And jury instructions are so very important, and there are cases that are overturned for lack of the right instruction, or you gave the inappropriate instruction. And then sometimes, that book she was talking about, here the judge referenced TPI, or Tennessee Pattern Instructions. Sometimes people will go to case law and say, hey, we need a special instructions. It's not in those red books behind the judge. This is something that we think is applicable to this case. And so jury instructions are very important. That's why they had what they call a charging conference this morning. So clearly, if something was wrong with those instructions, those would be raised on appeal. And she raises a point in juvenile court about non-cooperating victims. We see that a whole lot in domestic violence, okay?
But that doesn't mean the DA can't move forward.
Well,
oftentimes they do.
Yeah, they don't have
makes
a
it more
witness.
difficult.
You have the right of confrontation. And so unless a third party saw something happen, right, you can't have a police officer come in there and say, yeah, I talked to the victim and this is what they told me.
If there's physical injuries.
Well, still, I mean, we're talking about, hearing, if they don't cooperate or they don't want to, move forward, they could try to, the state even has the power, and I've seen this very rarely, the state, if there's a witness to a violent crime that doesn't want to participate, the state can go and get a special warrant to have that person arrested, held in custody, maybe 2 days before the trial to make sure that they participate.
Interesting. Okay.
That's very rare.
As always, good points, Ann. We appreciate it. Let's go to Mike. Mike, good morning. Hi, Mike.
Hey, Nick, thank you for taking my call.
Sure.
Hey, one thing I caught, I actually messaged you on Facebook. I didn't know if you were on Facebook watching, but he said that she came from the left, and the only entrance on 440 coming from the left is either from 24 coming in from Murfreesboro or it's coming 40 from the loop. And that's a good 6 miles or 7 miles from where her car stopped. So are we to think that she merged in right there, they shot her that quick, and she drove 7 miles with a wound that they said would have killed her in seconds?
I agree. That's the thing. That's why I questioned you before. That I know he said that she came from the left. That does not make sense to me, because I take that, and she was coming in from Lebanon. She was coming in from the right. Now, maybe it was farther along the way, and she had gone. Maybe that wasn't right then and there, and she did come in from the left. But he's absolutely right. The only way you can merge on from the left is coming from Murfreesboro. She was coming from Lebanon on 40, and that would have approached from the right. But it was probably farther down, perhaps, is when it happened.
And that's the very kind of thing the jury would talk about that wasn't in evidence, right? You're supposed, we don't know that, but people hey, I kept thinking in my mind that if you're the part of, because they said they got off and there were bullet casings at Sharondale. Oh, here comes the judge. Let's see what the ruling is.
Let's see what she decides. This should be interesting as Hill will continue.
Yesterday, that Bud has a filter that colors my gray and shades the dark. Bud left his glass.
I've never done you wrong.
You haven't, thank you. Let's see, where are Miss Sims and Mr. Chapman? Okay. Okay, so the court has looked at State v. Gomez. I'm sure y'all are familiar with that one. Well, it is a reported case from 2012, 367 Southwest 3rd, 237, and that's a case that this court has looked at previously when addressing the matters of opening the door, because it is something that is not always really clear. So I wanted to make sure that I considered the relevant authority when making that determination. So and Gomez and other cases on this issue have said, and I'll just read to you what I have indicated here: even if evidence is inadmissible, a party may open the door to admission of that evidence. A party opens the door to evidence when the party introduces evidence or takes some action that makes admissible evidence that was previously inadmissible. And so the question is whether or not, through his testimony, Mr. Hill has opened the door to evidence that's otherwise inadmissible. That particular evidence would be prior incidents or a prior incident. I don't recall the specifics in general. You'll have to, I guess, have that information. But it was I know that the court referenced it in a previous order, but it was an incident that involved Mr. Hill shooting, I believe, a family member or some family members, three family members in the past. And so in his testimony today, Mr. Hill, and I'm paraphrasing, I was very careful to make sure I was taking some good notes, but he said something to the effect that he should have known that by shooting that someone, he should have known that someone could get hurt. And I'm paraphrasing, I'm not quoting directly. The court finds that insinuates that he did not know that by discharging the firearm that he could have hurt someone. So with that insinuation, the court finds that is a sweeping claim that he did not know that he could have hurt someone. And I think as I look at Gomez and apply it in this case, I do think that the door has in fact been opened to introduce that evidence. Now, any further discussions on that?
Your Honor, I think the court can limit then what comes in. So we would ask that, the state, according to the court's ruling, the state would be able to ask whether or not Mr. Hill has shot a firearm before. We would ask that the question be limited to that. And hurt someone. Then the question is limited to that.
Well, then he shot and hurt his grandmother or the family members.
Your Honor,
He shot his grandmother and the other two grandchildren who were 12 and 6. His grandmother almost died, but even more, he said to her, "I got something for you," and reached in his closet, pulled out a gun, and started shooting at her and everyone else in the house. There were other children in the house. He only hit his grandmother and 2 children with the gunfire.
Your Honor, if the door has been opened to whether or not Mr. Hill should have known that discharging a weapon could hurt somebody, that's the court's ruling, that is what the door has been open to. Allowing any of those additional details is completely outside the scope of what the court has just ruled. I think that whether or not, I would submit if Mr. Hill were to get on the stand and then deny that shooting happened, then I think the state is within its right to impeach him with details. But I think asking, did you shoot at someone? Did you hurt someone? I think that sufficiently gets the state their impeachment material that they are asking for.
Okay.
The grandmother, whether it is his grandmother, whether it's his younger siblings, none of those details are relevant to the issue the court has found.
If I could just add, Your Honor, that's kind of like a prior conviction. You're not allowed to dig into the details of the prior conviction unless somebody denies specific facts of them.
And Your Honor, I submit this is a completely different situation. It is not impeachment for a crime of dishonesty. Mr. Hill took the witness stand and he asserted that he did not know that someone could have been seriously injured when he fired the gun out the window directly at a car. That he did not know that. He should have thought that. He has fired a gun at his entire family, struck his grandmother and a 12-year-old and a 6-year-old.
Well, I think I know those facts, or I'm familiar with that. I guess the question is, why not hold on, Mr. Chaffin, why not? And I'm just asking because I want to make sure that I'm considering everybody's position when I make my ruling.
I think
Why not what's the issue with limiting?
Well, I think limiting it, I'm trying to remember her exact limitation. First, she just wanted it that he fired a gun, but that he fired a gun and he hurt somebody.
And he injured somebody.
He fired a gun at multiple people and injured multiple people. We have several people in this household.
So what
he
would
fired the gun at all of them.
What would your question then be? I mean, because this is the out-of-court hearing that's required under that line of cases anyway. So what would your question be?
That he's fired a gun. He's fired a gun directly at someone, not just one person, but multiple people, and that he has struck 3 people with gunfire, and they were injured and seriously injured.
That would be your question in front of the jury?
Yes.
All right.
And just for clarity, because a couple questions later, when Mr. Hill was further explaining, he said, I went home and started searching when my mind got clear because I knew I could have hurt someone. So he definitely qualified.
Okay, but the door was still, I found that the door was still open. Okay, the court finds that question is appropriate as stated by General Norman on cross-examination. All right, Mr. Hill, and I think that we have addressed all the other issues that we talked about at the sidebar. I am going to ask the jury to disregard the comment about him being incarcerated for 2 years. I think that does not go to any elements of the offense, and preclude questions regarding what he's been thinking about for 2 years, because those do not go to the elements of the offense. All right, line them up.
She's lining them up.
I found the story that News Channel 5 did, Phil Williams had dug up at the time of his arrest. Juvenile records show Hill pleaded guilty to reduced charges of aggravated assault and was placed in the custody of the Department of Children's Services. Released him on a trial home visit back in 2017, all right? And it was a situation where a domestic shooting spree involving 4 family members, okay? Hill used a handgun to shoot his grandmother, 12-year-old sister, and 6-year-old nephew. That's basically what will be allowed, as you just heard the judge, because of what Hill said earlier in testimony, opened the door, and now the jury's going to hear that.
I think Cowan was feeling pretty good till that ruling.
Yeah, so how will this taint Cowan?
Because they're going to think, how do you hang out with somebody who shoots their whole family and they're riding with you and they all are shooting people? I think both of you guys are no good.
Gotcha. Looking at some of the details, 2 months after he was released in these shootings, just a week from turning 18, Hill was arrested again on an aggravated robbery charge after he and another person robbed a neighbor. That on top of the shootings of his family members.
It almost makes you feel like the law is unfair to some degree, right? I mean, as a layperson, I could see that, because you think, if I'm a juror, I want to know that.
Yes.
Okay, we may be seated. let the record reflect that the jury trial in this case is back in the format that should bring Mr. Chapman up. Ladies and gentlemen, just before the break, there was a comment, a question, and a response with regards to Mr. Hill being incarcerated. You are to disregard that comment and response. Go ahead.
That was my last question, actually, Your Honor.
Okay.
So
All right.
I don't have any further questions right now.
All right, Mr. Muckabo?
Yes, Your Honor. Morning, Mr. Hill.
Morning.
You had testified that that day preceding this, you were high. Is that right?
Yes.
I believe you said Xanax, cocaine, and weed. Is that right?
Yes.
Needless to say, you were not in your right frame of mind when you were cut off. Is that
I
correct?
wasn't.
And this happened in an instant.
Yes.
You had mentioned on direct that Mr. Cowan, you said didn't do this, and that's a general term. Let me ask you specifically, did he know you were going to do this?
No.
Did he solicit you to do this?
No.
Did he order you to do this?
No.
Did he direct you to do this?
No.
Did he command you or in any way help you to do this?
No.
Based on what happened that day, was he responsible in any way for what happened?
No, he wasn't.
And as he sits here, Mr. Cowan doesn't scare you, does he?
No.
Did he in any way tell you that you needed to testify or say anything about the fact that he did not have anything to do with this?
No, he didn't.
Thank you.
Okay, cross-examination from the state.
Yes, Your Honor. Mr. Hill, how old were you in 2020?
21.
Okay, and how old was your cousin, Mr. Cowan?
I think like 28.
Okay. And when you say that you're cousins, can you kind of explain, like, how are you related?
On my father's side.
Okay, but you said you've only known him a couple years, right?
Yes, like my brother reached out through him to get in touch with me, and then when I seen him, I was like, "What y'all doing together?" He like, "We all cousins."
Okay. Which, you're a 9/8 Mafia Crip gang member, correct?
Yes.
And within the 9/8 Mafia Crip gang, you actually refer to each other as cuz.
Yes.
I mean, like the guy you were talking to after you got booked on this warrant, his name in your phone was Big Cuz.
That's my big cousin.
Okay.
Like literally through my auntie.
And Mr. Cowan's a 9/8 Mafia Crip gang member.
Yes.
And y'all are in a gang together.
Yep.
And you had known Mr. Cowan for 3 to 4 years.
Yes.
And the whole time you've been 9/8 Mafia Crip gang members.
Yes.
And you hang out with them on a regular basis?
Not regular.
Not regular.
No.
Okay, so you hadn't been hanging out with him the weeks before this?
Yes, but you say on a regular basis. We don't hang on a regular basis.
Okay, just in November, December 2020.
I live in apartments. He come through there. He have other friends or people that he come see, and I will see him over there.
Okay, so you guys hang out, but you're not best friends.
No.
But you have done stuff with them. Y'all have gone down to Atlanta together before, right?
Yes.
You rode around in that gray Cadillac with the dark tint, dark rims.
Yes.
You had ridden with him before.
Yes.
And he knew some of your other friends,
Yes.
like Ari, Ocho.
I guess. I don't know who he know.
You don't know who he knows.
I don't know everybody he knows.
But you know Ocho, right?
Yes, I do.
But you don't know if Mr. Cowan knows Ocho.
No.
Because you don't actually know him like that.
Know who, Mr. Cowan?
Yes, Mr. Hill, Mr. Cowan. You don't know who his friends are. You
No.
might know someone that you know, but you wouldn't know that.
Who his friends are isn't my concern.
And so that day, you said that you went to your brother's house.
Yes.
And I guess when you left 1500 Porter Road, Panorama, you took the gun with you,
Yes.
the Springfield XD9.
Yes.
Now, was that the only gun that you had?
Yes.
And so you took it with you. Was it already loaded?
Yes.
And how many rounds did you have in the magazine?
I couldn't tell you.
You don't remember?
No.
Okay, well, so you have it with you
Yes.
to go to your brother's house to talk about your kids,
Yes.
and you felt the need to be armed.
I mean, I didn't feel the need. I just was that day.
You just were that day.
Yes.
Are you armed every day?
No.
In 2020, did you carry a gun every day?
No.
But you carried a gun that day.
Yes.
And you're saying that's the only gun that you had.
You said that day, and I said yes for that day.
What about Mr. Cowan? Did Mr. Cowan have a gun?
Not that I can recall.
You don't remember.
I didn't search his person, so I don't know if he had a gun or not.
But he very well may have had a gun. You just didn't search his person.
Yes, so I don't know.
You didn't pat him down, so he could have had one on him. And how long had you had that gun?
I couldn't tell you.
You couldn't tell me.
No.
A week?
Not. I couldn't tell you. I had it for a while.
A month?
I had it for a while, as I just told you.
Okay, had you ever fired it before?
No.
So you've had it for a while, you've never shot it.
Not until that day.
And so you said you went to your cousin's house, or your brother's house,
Yes.
with Mr. Cowan, which he goes by Duty, right?
Yes.
That's what you call him, right?
Yes.
And you guys hang out there for a little while, and you say when you leave, you don't actually know where you're going.
I didn't.
So you're just riding around with him.
You know, we had a specific destination to go to my brother. We wasn't just riding around.
Right, but when you leave your brother's, you don't know where you're going.
I knew we was going to pick his girl. I didn't know where from.
And you'd never gone with him to pick his girl up before.
No.
Did you know her?
His girl?
Yeah, Miss Carter.
Like, not personally, but I knew it was his girl.
So you had never met her.
Yeah, you could say that. Like, I've seen her, but I haven't just spoken to her.
Okay, so you'd seen her before, but you'd never spoken to her until that day.
I didn't speak to her that day.
Okay, well, you went and picked her up, right?
Yes.
And she got in the car,
Yes.
and you didn't speak to her.
No.
Didn't have any words with her.
No.
Okay, so let's talk about when you leave your brother's house. You said you didn't know what time of day it was, right?
I said it was dark or getting dark.
It was dark. And it was already raining, wasn't it?
I couldn't recall the weather that day.
Well, it was really rainy that day. You've seen the pictures. It was raining, it was dark.
No, in the pictures, it just showed that it was wet. It didn't show that it was raining.
Right, because it had already rained.
Yes, you could say that.
Right, so it was raining when you were driving, right?
I wasn't driving.
And you don't remember if it was raining or not?
No.
Okay. And what about the traffic? You know what time it was. You've been in trial, you've seen all the maps. It's right about 6 o'clock.
Yes.
So that's when everybody's getting off work. It's a Thursday. So there's traffic.
I guess so.
I mean, it's I-440, there's traffic, right?
Yep.
So there are other cars. Plus you guys are coming from Hermitage. There's definitely traffic coming from that way, coming into town at 6 o'clock, right?
Yes.
So there's a bunch of other cars around.
Yes.
And you said that she cut you off, right?
Yes.
She swerved in front of you,
Yes.
very specifically, and you said she came from the left
Yes.
and swerved in front of you.
Yes.
And that happened at what point in your route? You don't know.
No, I couldn't tell you specifically.
So it could have happened earlier on when you guys got on the interstate, right?
You know, I'm pretty sure it definitely didn't happen as soon as we got on.
Okay, so it happened sometime on your trip.
Yes.
And you said that when she cut you off, what did she do? I mean, did she honk her horn at you guys?
I mean, I don't believe she saw us. If she cut us off, so how could she honk her horn at us?
I mean, she might have thought that you weren't supposed to be where you were. Did she have any reaction whatsoever?
I don't know. I didn't even know it was a lady in the car at the time.
You didn't know that there was a lady in the car at the time,
No, I didn't.
but you did see the car cut you off, right?
I just seen, yes.
Okay. And what did Duty say when the car cut him off? Because he's driving, not you.
I couldn't recall what he said at that moment.
You can't recall what he said.
No.
So he said something.
If he did, I don't know what he said.
I mean, did he cuss? Did he yell at her? Did he call her the B word?
I don't remember all the facts. Just put it like that.
You don't remember all the facts.
Of him speaking, I don't remember. I don't recall him speaking.
So you remember facts, just none of the facts that have to do with Mr. Cowan.
I don't remember him speaking.
Okay, but you're not sure. You think you might have, but any facts about Mr. Cowan you don't remember.
I think she's asked it about 4 times now.
I'll sustain objection.
You said that it startled you when she cut you off.
I said it startled me when he smashed on the brakes.
Okay, so Duty, that's one fact you do remember about him.
I mean, we didn't run into the back, so apparently he had to smash on the brakes.
So he smashes on the brakes. A hard stop.
I guess so. We didn't hit the back of the car.
And you already have your gun out?
When I got in the car, I just took the gun off my hip and set it in my lap. It wasn't any specific placement.
You just set it in your lap when you got in the car.
I wasn't driving, so I just took it off my hip and put it in my lap.
And so was it already ready to fire, or did you actually have to rack the slide on it?
It was already loaded and just ready. It was,
So you had a loaded gun that was ready to fire, just sitting out on your lap.
yes.
So he slams on the brakes.
Yes.
And Mr. Cowan, when he slams on the brakes, what does he say?
Your Honor, it's 5th time.
I'm sorry.
That's the 5th time now that she's asked the same question. She asked again, when he slammed on the brakes, what did Mr. Cowan say?
Well,
He's already said, I don't recall. I don't remember he said anything.
Well, I think she's at a different specific point in the events on the interstate.
I still don't remember if he said anything at that moment.
You don't remember if he said anything at that point. So he might have, right?
I don't remember.
Did you say anything to him, Mr. Hill?
No, I didn't say anything. Like I said, I just acted very irrational and reckless in the moment.
So Mr. Cowan didn't say anything. He didn't say anything about being upset.
No,
How did you get him to speed up to go around Miss Kaufman?
I didn't get him to speed up. He just went around her. I didn't get him to do anything.
So Mr. Cowan on his own just accelerated to the point that he could catch back up with her and pass her.
We didn't catch back up, like we was behind her, and when she cut us off and he smashed on the brakes, we wasn't far apart and he just swerved around her.
And you decided that you were going to shoot her before he ever even went around her.
I didn't decide because I wasn't thinking. I just acted.
Mr. Hill, you decided to pick that gun up. You decided,
I just acted.
Mr. Hill, you decided to pick your gun up. You put it in your hand. It was on your lap. You didn't have it in your hand. Did you stick your arm all the way out the window? Or did you keep your arm inside the window when you fired the gun?
I don't remember all the facts of that. I just remember picking up the gun and shooting. That's it. I can't tell you how many times I shot. I can't tell you if I seen the woman. I couldn't tell you. I didn't see. Like, I just reacted recklessly.
You fired your gun over and over and over again. Mr. Cowan didn't slam on his brakes when you were firing the gun at Caitlyn Kaufman's vehicle. You were able to hit her car 6 times going 70 miles an hour, Mr. Hill. You know that.
I did not know I hit her car 6 times at that moment.
Because you were just firing over and over and over again. You decided that you were going to pull that trigger and pull it again and pull it again and pull it again. You decided to do that.
I just reacted. I wasn't thinking about anything.
Mr. Hill, you were firing a gun directly at a vehicle driven by another person. Could you see Caitlyn's face when you shot right into her window?
I just said I didn't see anyone.
You didn't see anyone. You just kept shooting. Did you think it was her or did you think it was somebody else?
I wasn't even looking. I just, in the midst of us driving, well, him driving and swerve around her, I just grabbed the gun and started shooting. I didn't look at anything. I didn't look at anyone, so I couldn't tell you who I saw or what I saw.
You didn't look at anything or anyone. You didn't look at where you were firing.
No, I just reacted.
And you want this jury to believe that you were able to hit that car 6 times without looking at it.
I mean, I'm just telling my story and telling from what I experienced. If they believe me,
You don't care.
I'm just telling my story. I'd rather be judged for my story than the stuff that y'all are saying.
But your story doesn't include any facts about Mr. Cowan.
He didn't do anything. He didn't help or aid or abet, solicitate. He didn't do anything. He didn't know this was going to happen. I didn't know this was going to happen. It just happened in an instant.
Mr. Hill, it didn't happen in an instant. You fired your gun over and over and over again. That doesn't happen in an instant. That is decision after decision after decision, Mr. Hill.
As I recall yesterday, the expert said the trigger is very light and it can be pulled very fastly, like with no pressure. So it didn't take time to think. I just reacted, as I said.
So you don't know that because of what you did. You know that because of something you heard that's an excuse for you to use in this trial. Isn't that right, Mr. Hill?
No, I'm just stating that from what I know, I just reacted.
You just reacted to Mr. Cowan slamming on the brakes because someone cut him off.
I just reacted to the situation.
And Mr. Cowan, what did he say to you after you fired your gun? A minimum of 6 times. You don't know how many, so most likely many more since you weren't even looking at the target.
He told me I was bullshitting and why did I do that? What was I thinking? And I told him specifically, I wasn't thinking, I just reacted. I know I'm bullshitting.
You were bullshitting.
Yes, basically, I made that stupid decision. So when people make stupid decisions, they're bullshitting, like tripping.
So Mr. Cowan told you that you made a stupid decision.
Basically, yes.
You made multiple stupid decisions. He told you you were bullshitting.
Yes.
He knew exactly what you did.
Yes. But he didn't know I was going to do that.
Mr. Hill, did you do that to impress Mr. Cowan?
I don't worry about impressing the next man.
You don't worry about impressing the next man.
No.
So you're just riding around in a car with your cousin, Duty.
We wasn't just riding around. We had 2 specific destinations.
What was the other specific destination?
To go pick his girl up and to go to my brother's house.
So you're going to pick up the girl that you've seen before but you've never spoken to before. You're riding around with your cousin Duty, and you just all of a sudden, out of nowhere, decide to start bullshitting and make some stupid decisions. And you did that to impress your cousin Duty.
I wasn't impressing him, as I just stated, and I wasn't just riding around and decided to bullshit. At that moment, I made a irrational and very stupid decision at that moment.
You made multiple decisions. Every single time you fired that gun, you made a decision, Mr. Hill.
It was all at that moment. That's one decision.
So, Mr. Hill, eventually you get back to 1500 Porter Road to Panorama, right?
Yes.
And you get back home, and you are actually searching for this shooting before the parks officer ever finds Miss Kaufman.
Yes, because I eventually thought about what I had done and realized that someone could have been hurt.
You eventually thought about it.
Yes, as I stated, I was intoxicated on multiple drugs and my mind wasn't in the right state.
And you didn't call 911.
I should have.
You didn't call the police and tell them that somebody might be hurt on I-440.
I should have.
You should have.
Yes,
Absolutely.
I should have.
You should have. Mr. Cowan should have. But you didn't, did you?
No, I wasn't thinking. I was in the...
You didn't call and tell anyone. You started messaging people trying to get rid of your Springfield XD9.
Yes.
And not just get rid of it, you wanted to trade it. You weren't just trying to get rid of the evidence, you were actually trying to get something back for it.
Yes.
And eventually, your friend, Mr. Merrill Odom, which he is not a 9/8 Crip, right?
No, he's actually a member of Blood.
He's in a completely different gang, but you guys are friends because you grew up together when you were younger.
Yes.
So that's why you're still friends. Well, you were still friends.
Yeah.
So you talk to him and you get him to trade guns with you.
He offered to take the gun from me.
Was that after you told him what you did?
Yes.
So you told him, I used this gun to kill Caitlyn Kaufman. I fired at her vehicle multiple times. I hit her, I killed her. Trade me this gun.
I never said trade me this gun.
Well, but you got his M&P 40.
After he offered to get rid of the XD.
So he offered to get rid of a murder weapon for you, and it wasn't a trade when you got a new weapon for it?
You saying I traded with him. He offered and he was like, "Hun, take this." I didn't specifically tell him trade me his gun. What you're trying to say?
So you're saying that Mr. Odom just gave that gun to you out of the goodness of his heart?
I can't tell you what he was thinking out the goodness of his heart. I just know he offered to get rid of the gun, and I was like, okay.
So Mr. Odom offered to help you destroy evidence of the crime that you committed, and you were like, well, since you're offering, I guess I'll take you up on it, sir.
Basically, yes.
And he just gave you the Smith & Wesson M&P 40 that you had at the time the police came and arrested you.
Yes.
The one that you were gonna toss out the window, except for those flashbangs that they threw in the apartment.
I don't know anything about tossing a gun out of a window. Where did that come from?
You said it when you were talking to Big Cuz after you got booked.
No, I never said that, and I don't know what you're talking about. I don't recall saying that at all.
So you had the M&P 40, but you weren't planning on tossing it.
If I was planning on tossing it out of a window, I wouldn't have threw it under the bed. I threw the gun under the bed when they kicked the door in. If I was going to throw it out the window, I would have threw it out the window.
So you had the gun on you when they came in and you threw it under the bed.
I was asleep laying, and it was laying beside me.
Your Honor, I don't necessarily mind his line of questioning, but I don't see how it's relevant to the case.
You have a response. Relevancy.
I think it's very relevant. He's talking about getting rid of the murder weapon and saying that somebody handed him a gun, but it's a statement that he made in his jail call, and he's denying that he made it.
Look, if she wants to impeach him with a statement he made in the jail call, she can do that. What he did with a weapon that's not the murder weapon and is not an illegal weapon or anything he's charged with in regard to this case is irrelevant. The M&P 40 was not the murder weapon. And if he said something in a jail call, be presented with it so he can confirm
If
it or
you're
not.
going to impeach him, General, just straight out impeach him. If that's what you're intending to do, I think that's what the objection is.
So you get rid of the murder weapon.
Yes.
You think you're in the clear.
No, I said that it was still on my mind that something could happen and take me away from my kids, so I did not think I was in the clear.
Okay, but you didn't call the police.
No.
And you saw the news. You saw that the reward that was $1,000, it went up to $6,000, right?
No, I wasn't paying attention to no reward. I wasn't searching rewards. I just saw the news clippings.
So are you saying you didn't know that the reward jumped up to $16,000?
No, somebody called me and told me the reward jumped up to $66,000 the day before I got arrested. So I did not know up until then.
Someone called you the day before you got arrested and said the reward is $66,000.
Yes.
Okay, so you did know that there was a reward.
At that moment, the day before I got locked up, yes, I did know there was a reward.
And you had the information about who shot and killed Caitlyn Kaufman.
Yes.
That it was you and that Duty was driving the Cadillac when you shot and killed her.
Yes, I had the information.
And you didn't call the police.
No, because I was still scared. I have a lot to lose if I was to just end up in jail behind this.
You have a lot to lose.
Yes, I have a family. I have 2 kids, a son and a daughter.
And you didn't call Crime Stoppers.
No, I wasn't trying to collect a reward or anything.
But you got arrested
Yes.
because you did this.
Yes, I did.
And when you got arrested, you agreed to talk to the detectives.
Yes.
And when you talked to them, you lied to Sergeant Dickerson.
Yes, because as I said, I have a lot to lose if I was to end up in jail, which I lost a lot since I've been in here.
Mr. Hill, you lied to him. You told him that you weren't even in Nashville, Tennessee. You lied to him and told him that you drove to Atlanta, Georgia, didn't you?
I just agreed to you that I said I lied.
You were charged with the homicide of Caitlyn Kaufman. They told you that's what the interview was about, and you lied to them.
They didn't tell me that until after they showed me the phone maps that I was on the scene of that. They didn't say when I first went in there that I'm being charged with the murder of Caitlyn Kaufman. They never said that.
So, Mr. Hill, your contention is that during that interview, when Detective Dickerson told you it was about the nurse and it was that case and was asking you questions if you had seen it in the news, that you didn't realize until he threw that cell phone map down what he was talking about.
He kept asking me, like, why did I think that? And I told him specifically that somebody had to mention my name in this.
Right, you knew it was Jacquez. You knew it was Gucci.
At the moment, I didn't until after certain facts that the detective told me. Then I put 2 and 2 together that it was him.
The certain facts were Duty and the Cadillac.
Basically, yes.
But you sat there and you lied to him and you were going to keep lying to him.
At the time, I was scared and didn't want to be in trouble. This is a serious crime. So I was going to protect myself and my family at the same time.
Right, you were going to protect yourself and your family. And it wasn't until he laid that picture down that said, "You're lying." And at that moment, you admitted to being there in the Cadillac.
Yes.
You admitted to that, but you kept lying to him, and you told him that you were driving. And you weren't the driver, Mr. Hill, were you?
No, I said I was protecting myself. I was not ready to step up and own up to this. I already said all this.
Mr. Cowan was the driver.
Yes, and he didn't do anything to help aid, assist, solicitate, or anything. He didn't tell me to do this or anything.
Because you're protecting your family. Mr. Cowan, you're protecting Mr. Cowan.
I said at that moment I was protecting my family, but since I'm telling the truth, I'm going to tell the truth. He didn't do anything. He didn't aid or assist me in any crime that I committed. He didn't do nothing.
And when you were lying to Detective Dickerson and telling him that you were the driver and that it was your passenger, you named a person, Quan Evans.
Yes, I made up a random name, and if that person was to be brought into this, then I would have to step up and own up to my stuff still. So regardless of the situation, as long as I've been locked up, I've been ready to give the truth.
You were gonna let Quan Evans get arrested for the murder of Caitlyn Kaufman. They brought you a picture, you said, "That's him, he's the shooter, I was driving."
Yes, we seen
That
it.
is what you said to Detective Dickerson.
Yes, we all seen it.
And the one thing you wouldn't say to Detective Dickerson is about Mr. Cowan. You kept protecting him. They asked you if you knew him, ever seen him before, and you said no.
I did.
You denied knowing him at all.
Yes, I did. He didn't do anything wrong.
He's your cousin. He's your 9/8 Mafia gang member friend.
No, I consider him, we're family. We're more than gang. This goes deeper than gang stuff.
Deeper than gang stuff.
Yes, we're family, so blood comes before the gang.
Well, Mr. Hill, you would agree with me that gang members, they cover for each other.
Everyone covers for themselves when they're in trouble or need to be protected.
And they don't tell the police about what somebody else did. That's a rule. That's a violation.
My culture and my community, talking to the police, that's just in general. So even without being a gang, people in my community still don't talk to the police.
But Mr. Hill, you did talk to the police. You told them that you were involved, but you wouldn't tell them that Mr. Cowan was involved.
No.
Because you were covering for him. You were protecting him.
Yes, he didn't do anything.
He was driving the Cadillac that you were in when you were able to fire all of those shots at Caitlyn Kaufman, Mr. Hill.
Maybe he was driving, but he didn't do anything wrong. I did all the crime myself. He didn't tell me to do it. He didn't help me do it. I done this on my own.
You fired all of those rounds at Caitlyn Kaufman. You did that. Every single
I just said that.
decision was you.
Yes, I just said that.
Now, Mr. Hill, your testimony to this jury today, which you have sworn to testify under oath, is that this was really bothering you, right?
It was.
But you were at Mr. Cowan's birthday party on December 5th,
Yes.
and you were partying it up.
Doing drugs. I specifically said I was doing drugs and out of my mind. trying to cope with the situation, which I wasn't.
And you also said that you were on drugs when you were in the car, right?
Yes.
And so your memory probably isn't super great, wouldn't you say?
It isn't.
And you don't remember certain facts, right?
I don't remember, no.
Certain ones, but you remember some of them.
For the most of it, I remember.
And after you got charged with this, you're the person on all of those calls that we heard, right?
Yes.
And you're calling people, you're upset about Jacquez Merrill Odom, Gucci, because he told on you.
Yes.
And you want people to know that he's the one that told on you.
Yes, I just put it out there. It wasn't nothing specific.
You put that word out on the street so everybody would know that it was him.
Yes.
And you wanted to know how that was going to work, if he was going to be forced to come to court to testify against you.
Yeah, I just was wondering.
Because you wanted to get the message out to him that he shouldn't do that.
No. Where did that come from?
Oh, you wanted him to come to court and tell the truth about you.
I didn't want to get a message to him. I never tried to reach out to him or anything.
Right, you just told Big Cuz exactly who he was, but you had to go into great detail to explain that to him.
Yeah, I just tell him who he was, let him know the person that put me in this position. I didn't tell him to do anything to anyone. I didn't ask him to look him up, call him, reach out to him. Anything that he said was on him.
That's on him, not on you.
Yes, I didn't tell nobody to do anything.
So when he told you he was going to bump down on him, that's on him, not on you.
Yeah, and I told him you're not going to see him, cuz. So I let him know basically like to leave it alone. You're not going to find him. You're not going to see him. So basically leave it alone. And that was it.
You gave him specific details about him and he said he was going to go bump down on him. But that's on him, not on you, right?
Yes, if he decided to go say something to him, that's on him. I have nothing to do with that.
But the one thing that you wanted Big Cuz to do, other than know that it was Gucci, Jacquez Merrill Odom, you wanted Big Cuz to let Duty know that you didn't say anything about him. It was Jacquez that said his name.
Yeah, basically, like, let him know that I didn't say anything about him.
That you hadn't snitched on him. It was Jacquez that snitched on him.
Yeah.
And you wanted him to know all of the specific information that the police had. They had his picture, they had his phone, and they knew about his Cadillac.
At that time, I wasn't letting him know. I was telling my family what was going on and what was said to me. It wasn't a warning to anyone. That was just me talking to my family, letting them know. I done the same thing with my sister. I let her know everything that the police was saying to me and what was going on.
Which they already knew what you had done.
No, my family didn't know anything I have done. I never told them about this incident.
You never told them about that incident.
No, I did not. I kept it to myself, and apparently I told Mr. Odom, which was another irrational and stupid decision that I have made.
So you're saying that Frederica and Big Cuz, they didn't know what you did?
No.
You never told them?
No, I did not.
You told Jacquez Merrill Odom,
Yes.
and he's the person that you told about what you did, that you shot and killed Caitlyn Kaufman.
Yes.
And you sat here today on direct and told this jury that you didn't know that someone would be seriously injured when you fired your gun multiple times out of that window.
I said I should have known because I wasn't in the right state of mind and I wasn't thinking. I should have known someone was harmed.
You should have known because you fired a gun before.
And I said I wasn't thinking at that moment.
Mr. Hill, you should have known because not only have you fired a gun before, but you fired a gun that has hit someone. Your bullets have struck another person.
Yes, they have. And at that time, I was young and made a stupid and irrational decision at that time. And them same people that was harmed forgave and still showed me unconditional love.
Mr. Hill, you fired a gun not at one person, not at two people, at multiple people, and you've struck 3 people with your gunfire before.
Yes.
And they were injured.
Yes.
Anything ready to read?
No.
Mr. Hill, watch your step or just step it down, please. Mr. Defense, ready to, you have additional witnesses?
Yes, we call Dr. Eric Warren.
Dr. Eric Warren.
Sir, if you would, raise your right hand, please. Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Good morning, Dr. Warren. Can you introduce yourself to the jury, please?
Yes, my name is Eric Warren. That's spelled E-R-I-C. Last name is W-A-R-R-E-N.
And what do you do, Dr. Warren?
I own my own forensic consulting firm. It's called SEP Forensic Consultants, and that's spelled S-E-P Forensic Consultants. We're based out of Memphis, Tennessee.
How long have you owned that company?
5 going on 6 years now.
What did you do before?
Prior to starting that consulting firm, I was employed by the Tennessee Bureau of Investigation for approximately 9 years. I was assigned to the Firearm and Toolmark Identification Unit, initially here in Nashville, and then I was transferred after approximately 2 years to the Memphis Regional Crime Laboratory. In addition to being assigned to the Firearm and Toolmark Identification Unit, I was also a member of the Violent Crime Response Team, where I served as the firearm or shooting reconstruction expert on that team of typically 5 people.
And why did you decide to leave the TBI and start your own company?
So my educational background is actually, went to undergraduate and graduate school at Vanderbilt University here in Nashville. And my education background is in molecular and cellular biology with a doctorate in molecular biophysics. So at the time that I was in school, I knew that I wanted, with a love of math and science, I knew that was the type of field I wanted to pursue. And it was at a career fair that I was introduced to the world of forensic science. So when I joined the TBI, I still had that desire to combine the research element with the forensic science element, and the Bureau just is not a place that you can do that. And so I left to start my own company in order to be able to pursue both.
So do you consult on cases and also do research as part of your work?
Yes, that is correct.
Dr. Warren, do you know Devontae Hill?
No, I do not.
Do you know James Cowan?
No, I do not.
How did you come to be involved in this case?
I was contacted by Attorney Chafin and asked if this is something that would fall within my area of expertise. We agreed that it was and pursued approval for funding for the case.
And what specifically did you do to begin analyzing this case?
So typically my workflow, if you will, is I will request what's called discovery materials. So specifically what I reviewed in this case would be crime scene photographs, any diagrams that were taken at the crime scene, officer supplements, that's their description of what each individual officer did at the scene or what they observed while they were there. I've taken all these various data points, including the medical examiner report, the autopsy photographs. If any 3D laser scanning is done, I will request that data and do an examination of that as well. And essentially what I'm doing is I'm combining all of those fields of chemistry, biology, math, and looking at it in a holistic way, in a big picture type of way, to see what type of scenarios would encompass and be most consistent with all of the data as a whole.
When we initially contacted you to consult in this case, did we have a specific question for you, or what was your task initially?
So my task was specifically to focus on bullet defects in a vehicle, and just to see if there was anything that, as I put all these pieces of the puzzle together, if there was any type of opinion that I could form regarding how those bullet defects might have ended up the way that they appeared.
Did you ever see this gray Mazda SUV in person?
I have never seen the specific gray Mazda in person, no.
Did you personally collect any of the evidence in this case?
No, I did not.
Did you physically examine any of the evidence in this case?
I did not.
Did you ever go to the scene or take measurements or do any other crime scene analysis at the scene?
No, I did not.
Because you didn't personally do any of that type of investigation, does that impact the opinion you give us or the validity of any of your findings?
No, it does not.
Why not?
So in the majority of shooting incident reconstructions or crime scene reconstructions that I do, you're reliant on, again, a number of those data points, whether that's the report from the firearms unit, whether that is a laser scanning data. All of these things don't require me to be present at the scene. I can rely on all of these other methods as individual data points as I start to put, again, all the pieces of the puzzle back together.
You mentioned a minute ago that we pursued funding. How are you paid for your services in this case?
So I still get paid this from the state of Tennessee as was when I was with the TBI.
Is there an hourly rate that you are capped at or that is set?
Yes, I believe the Supreme Court set the rate at some point in the past.
That's not a rate you choose.
No, it is not.
Now that you're working as an independent consultant, who typically hires you?
So I make my services available to both prosecution and defense, and as such, I work for both sides, as well as the military, as well as civil cases as well, so insurance companies, individuals.
And when you worked for the TBI, were you working for both sides at that point, or did you testify for one side or consult for one side more than the other?
Sure. So the TBI is a law enforcement agency, and their customer is the law enforcement and the district attorneys. So with the TBI, we would only receive evidence from essentially the prosecution.
So for the 8 years that you were with the TBI, what percentage of your cases were you a prosecution expert witness?
100% of them.
And now what is that percentage?
Roughly, right now it's 50-50 for each side.
When you worked for the TBI, did you ever change your opinions or your testimony to line up with what the prosecution wanted you to say?
No, I did not.
Now that you're an independent consultant, do you change your opinions or your testimony to line up with whatever party hired you?
No, I did not.
Why not?
So again, the motto of our company, everything that we do at our company surrounds the science and the direction that the science leads us. And so everything that I will bring in will be either dependent on my own specific empirical testing or based upon the empirical or scientific testing of other experts or that has been published in the peer-reviewed literature.
Dr. Warren, I'm going to hand you a document. Do you recognize that document, Dr. Warren?
Yes, I do.
What is it?
So this is a copy of my CV.
What's a CV?
It's essentially like a long form resume, if you will, that lists everything about education, training, and experience.
And you've told us a little bit about your educational background. I'll come back to a few other relevant points in a minute. Is that a fair and accurate copy of your current CV?
Yes, it is.
I'd like to admit that as the next exhibit, please, Your Honor.
Okay, I think we're 43.
And I'm sorry, do you need to hold on to that to talk about your training and experience, or do you?
I think I'll be okay.
Okay. Thanks. So, Dr. Warren, you told us that you received your undergraduate and your doctorate from Vanderbilt University. In addition to your sort of formal education background, have you received any specialized training in the area of firearm and tool mark identification?
Yes, I have. So when I was initially hired by the TBI, I underwent an intensive 2-year on-the-job training program. And that consisted of reading textbook type materials, journal articles on the history, the manufacturing, and the methods of firearms and firearms identification. It also included touring the manufacturing facilities of many firearms and ammunition manufacturing plants to see kind of a behind the scenes view up close the types of manufacturing processes that occur when firearms or ammunition are manufactured. And then that all culminated with a mock trial where I was given mock evidence that would encompass the entire range of firearms, trajectory, all of that, and successfully completed that and then was signed off to do independent casework.
And what about in shooting incident reconstruction? Have you had any specialized training in that field?
Yes, so in addition to it being part of that on-the-job training program that I just mentioned, I've also attended external training through the FBI, the ATF, a few different universities, for instance, West Virginia University, that offer forensic type courses. And then I've also pursued from private companies that specialize in shooting reconstruction, training in that as well from those companies that can be in the form of either an online seminar or in some cases up to a week-long on-site course.
Do you have an estimate of how many hours of extra training beyond your PhD you've received in these areas of expertise?
So after post PhD with the TBI and currently up until now, it's somewhere in the hundreds of hours of training.
What percentage of those hours are in firearm and tool mark identification?
I would say the majority of that is firearms and tool mark, so probably somewhere in the 50 to 60 range potentially.
What about shooting incident reconstruction?
So the shooting incident reconstruction and kind of the bigger picture crime scene reconstruction would be the remaining percentage of that.
Have you produced any peer-reviewed publications on either of these subjects?
Yes, I've produced 5 or 6 peer-reviewed publications in these types of forensic areas, with a few more that I'm currently in the process of getting published. I've also instructed in some of these areas as well at the Tennessee Law Enforcement Training Academy, as well as directly to specific law enforcement agencies in advanced topics of crime scene reconstruction and shooting incident reconstruction.
And just briefly for the jury, what is the significance of a peer-reviewed publication?
Sure. So with peer-reviewed literature, you would essentially do that empirical research, that scientific examination and generation of conclusions and results. You would write it up and you would submit it to essentially an editorial board where the relevant members of that particular community would review your work and essentially kind of pick it apart, not just proofreading, but making sure everything is sound scientifically. And then they may ask for revisions before it is actually published. And so the idea is with peer-reviewed literature, you know that if it's been published, it has been reviewed by multiple independent experts and has been deemed to be sound.
Are you a member of any relevant professional organizations relevant to the two subjects we're talking about here?
Sure. So I am a distinguished member of AFTE, which is the Association of Firearm and Toolmark Examiners, where I also serve on the board for unpublished research. I serve as the chair of the Committee of Unpublished Research, and I am an assistant editor of their peer-reviewed journal. I'm also a member of the International Ammunition Association and a member of the Association for Crime Scene Reconstruction.
And all of these things we're talking about, are they contained in your CV?
Yes, they are.
Have you ever been qualified to testify as an expert witness before?
Yes, I have.
How many times?
Somewhere in the neighborhood of 70 times.
And are those times that you have been qualified in the area of firearm and tool mark identification?
Yes, I would say probably 70% of those times were firearm and tool mark examination.
And what about in the area of shooting incident reconstruction?
Yes, so the remaining percentage would be in shooting reconstruction or what's kind of a broader field of crime scene reconstruction, but that would also encompass shooting incident.
Your Honor, at this time we tender Dr. Warren as an expert in the fields of firearm and tool mark identification as well as in the field of shooting incident reconstruction.
Okay, Mr. Monkler, is there any report on that, Mr. Cowan?
No, Your Honor.
Water from the state?
No.
Okay, ladies and gentlemen, Dr. Warren has been tendered to you as an expert in the field of firearm and tool mark identification and shooting incident reconstruction. And we've gone through this a few times in terms of me explaining to you the weight given to those who are tendered to you as experts. There'll be a more detailed explanation of that in the jury instruction. Okay?
Dr. Warren, I want to start by asking you about some of your sort of ultimate conclusions or opinions that you came to after reviewing all of the materials you told us about, and then we'll back up and sort of talk about how you got to those particular conclusions. So my first question is, how quickly, in your opinion, could 6 shots have been fired from the Springfield XD that's at issue in this case?
Sure. So again, I will rely on peer review literature for this, but an average person could fire or discharge 6 shots somewhere in the neighborhood of 1 to 3 seconds.
Based on the totality of the evidence that you reviewed, do you have an opinion as to what the most likely scenario for how this shooting incident occurred is?
Yes, I do.
What is that opinion?
So based on, again, I'm pulling multiple data points in, based upon movement at approximately 70 miles an hour on the interstate, with knowing that the ability to discharge 6 rounds in a few seconds, and the particular angles that are present on the vehicle in question, all of these would be consistent with a very rapid incident. Again, happening at a high speed, 70 miles an hour approximately. And all of the evidence together indicates what I would say is relative velocity or relative motion. And I can explain that if need be.
And yes, I will need you to do that, but let's save that for just a minute and talk about a couple of your other conclusions. In your opinion, is the strike pattern or the defect pattern that we see on the Mazda, is that consistent with the car from which the gun is being fired, that car pacing or driving alongside the Mazda at the same speed?
No, it is not.
Why not?
So if 2 vehicles had no relative motion between the two, so essentially with one with respect to the other, there's no difference in speed. So we can think of it's the same as if neither are moving. All of the shots and therefore all of the defects would be concentrated in one particular area of the vehicle, and they would all have roughly the same horizontal, or what I call the azimuth angle, which is basically is it left to right or right to left. And so that if there's no relative motion and the 2 cars are riding next to each other at essentially the same speed, it would be inconsistent with the type of physical evidence that was present on the vehicle in this case.
Is the strike pattern or the defect pattern on the Mazda, would that be consistent with the shooter hanging out of the passenger side or doing something with their body to attempt to track the vehicle as their car drives quickly by?
No, it would not be. So again, we have that relative motion, and the majority of what gives that away or shows or illustrates that was the case is what I referred to again as the azimuth angle or the horizontal angle. Now there's another component called the vertical angle. So that's, is the shot going down or is it going up? If there was somebody, as proposed, hanging out of a window or actively trying to take a shot, I would expect a change in the vertical angle as that individual attempted to move and reposition themselves. And in this case, again, that's inconsistent with the data. They have essentially all the same vertical angle.
And one more opinion before we sort of break all of these down. In your opinion, did Ms. Kaufman react to shots being fired at her?
I do not believe that for at least the first 2 shots that there was no reaction by Ms. Kaufman.
And what is your opinion on that based on?
So again, thinking that you can do rapid fire shots and looking at those azimuth angles, the horizontal angles, between the first and second shot, so the rearmost shot and the one into the front driver's side window, the trajectory of the bullet that left the defect in that window was described by the medical examiner as having an almost straight across trajectory, slightly front to back. And so we have the trajectory inside of her body and we have the bullet defect. And so you can actually align those two up to say that essentially she would have been facing forward. The torso would have been facing forward at the time that second shot was fired.
I want to go back. Ms. Whitaker gave us some vocabulary and talked to us about sort of the vocabulary of ammunition, that vocabulary of firearms, and as you know, I'm sometimes not the greatest, so correct me if I am using the wrong vocabulary. But can you give us just a quick lesson on how the Springfield XD, what type of gun it is and how it fires?
Sure. A Springfield XD, it is a striker-fired semi-automatic pistol. So there's a couple of terms there that I'll kind of walk us through. So striker-fired, that is different than what you would think of when you think of a revolver that has a hammer that comes forward and hits a firing pin, and it's the velocity of the inertia, the energy that hammer is carrying forward as it strikes the firing pin that makes that firing pin hit the ammunition and discharge. With a striker-fired firearm, there is no hammer in that conventional sense. It's essentially just a firing pin by itself, typically called a striker, that is pulled back under spring tension, and it is that spring tension, that force there, that causes the firing pin to go forward to strike the ammunition that's in the firearm and discharge. Now, semi-automatic pistol is different from, say, a fully automatic pistol, and the reason it's called this is because a semi-automatic pistol requires the trigger to be squeezed or pulled for each shot that is fired, whereas a fully automatic, you would press the trigger to the rear, hold it, and as long as you are holding that trigger rearward and there's ammunition present, that gun will continue to fire. With a semi-automatic, the reason it's called that is because there are several steps that happen internally automatically. So a semi-automatic pistol, again, does require the user to squeeze or press that trigger, but then there are tools called the extractor and the ejector inside of that firearm that will automatically, upon discharge, extract the fired round and eject it from the gun and then load the next live round in to fire it. Now, I'm using these terms, but the official terms that you'll probably hear me use going forward, I'd like to define those real quick. So a live round of ammunition, a single live round that I've called a round so far, is technically called a cartridge. So this is an entire unit of ammunition, and it contains four main components. But the two that are most important that we're going to talk about is the cartridge case. Some people call it the brass or the casing. That's that individual shiny piece, typically like a golden color, that is extracted and ejected from the firearm. And there's also the projectile or bullet, which is what travels down the barrel and down range.
So I want to talk now about some characteristics of this Springfield XD. Did you examine that firearm yourself?
I did not.
Okay. Did you review any reports related to that firearm?
Yes, I did.
And what did you review?
So I reviewed, I believe it was 2 reports from the Metro Nashville Crime Laboratory, as well as the entire case file that accompanies those reports, so that the reports will indicate the testing that was done and the conclusions of that particular examiner. The entire case file will actually show all of the photographs and documentation that they generated in the course of creating that report and forming those opinions.
And did you also, were you also able to see Ms. Whitaker's testimony day before yesterday?
Yes, I was.
So one of the things Ms. Whitaker told us is that the cartridge casings were determined to have been fired. There are 3 cartridge casings that were determined to have been fired from the Springfield XD. Do you have an opinion as to whether that finding is correct?
I have, reviewing the notes, I have no reason to doubt that that finding is correct.
And Ms. Whitaker also told us that the trigger pressure for the Springfield XD was 4.75 pounds. Where does she get that number from?
So that is a number that would be calculated essentially using what's called arsenal weights, and that would be a metal rod with a hook at the end of it, and at the bottom of that metal rod is a plate where weights can be added. And so the way that that trigger pull is determined is the firearm would be held vertically, aiming at the ceiling, and that hook on that rod would be placed onto the trigger, and then weight would be added to that until that gun went click, which, if it were loaded, would indicate a discharge. And what that is essentially measuring is the amount of force that would be required to pull that trigger rearward to engage the striker portion, the sear portion of that striker or firing pin, and then retract it and then let go to cause that discharge. So that whole process would be what is measured by that trigger pull.
Have you ever conducted research or experiments on the amount of force it takes for humans to sort of apply force in other settings? For those of us who have never pulled the trigger on a gun, how do we know what 4.75 pounds of pressure feels like?
Sure. So yes, I like to always have examples for various different aspects in order for people to have a good idea of what that would be like. And so this 4.75 pounds would be most comparable in the testing that I've done to something like if you were to take a single finger and try to squeeze a Windex bottle. So not with your full hand, but just with a single finger.
And do you have, after reviewing the full file, do you have any reason to doubt that calculation? I believe it's actually Ms. Ms. Chambers performed to determine the 4.75 pounds of pressure.
Yes, that is correct. I believe it was Ms. Chambers, and no, I do not have a reason to doubt that.
Is that consistent? Is that that pressure, that force required, is that consistent with your knowledge of this type of firearm?
Yes, it is.
And is that consistent both with the Springfield XD in particular, as well as other similar semi-automatic pistols?
Yes, it would be similar to other striker-fired semi-automatic pistols, such as a Glock or a Smith & Wesson MMP.
Have you ever done any research yourself? Are you familiar with research that tests how quickly? Well, let me ask this first. Have you done research specifically on the Springfield XD to test how quickly that particular gun can be fired?
No, I have not.
Have you done research, or have you reviewed any other peer-reviewed research that determines how quickly a similar style gun can be fired?
Yes, I have.
Can you tell us about that?
Yes, so that was specifically an article by Mr. Jason Alexander, who's also a member of AFD and for a long time has been putting shooting incident reconstruction literature out and getting that published. And he looked at several different types of shooters, so from novices that have never touched a firearm to just an average person that has some experience to law enforcement officers or professional competitors. And he looked at this exact question of how quickly can a trigger be pulled. And those measurements varied, of course, depending on the skill, but in general, a novice never touched a gun can fire 1 to 2 cartridges or rounds per second. The average person, with kind of like the Goldilocks idea, the Goldilocks story, the person in the middle, can fire somewhere in the 4 to 6 rounds a second, and then competitive people are more in the 8 to 9 rounds per second.
And in that research, was a Springfield XD particularly used in that study?
No, it was not.
Is there any reason why we can't extrapolate from the findings using other weapons in that study to the Springfield XD?
No, there's no reason why that couldn't be extrapolated. That's part of the scientific process. You factor in many different variables so that it can be applied in other scenarios.
I also want to ask you about a feature on the Springfield XD related to the trigger pull. When you described the process to us of pulling the trigger, and that is what causes the, I'm not going to try to repeat. You described us the process, you pull the trigger. In order for the next round to be fired, once one round is discharged, in order for the next round to be fired, does the trigger need to return all the way to the fully frontwards position before it can be fired again?
No, it does not.
Can you tell us what happens instead?
So there's a feature called a trigger reset. And if anybody's ever been to a gun range or fired a gun, you know that once there's a lot of what's called take up, so you have to pull the trigger back quite a bit of the ways before you start to feel that there's that engagement that I talked about. And then you have to continue to squeeze the trigger to overcome that engagement such that the sear is tripped and the gun discharges. When that happens, again, part of the semi-automatic process, there's a tool inside of the gun called a disconnector. That disconnector serves to prevent that gun from firing fully automatic. That's one of the aspects that's required for a gun to have to be semi-automatic. And so when you squeeze that trigger and the firearm discharges, you then have to release the trigger in order to trip that disconnector so that you can pull the trigger again. However, you don't have to let the trigger all the way forward because there's that section of travel that's called take up. So you really only have to release it until you hear an audible click or feel a click from that disconnector, at which point you can stop letting go and squeeze again. And that's typically somewhere in the neighborhood of only 25 to 50% of the full travel.
Dr. Warren, I want to turn your attention now to the trajectory analysis that Officer Belcher did. Were you able to, as you described to us, you were able to review Ms. Chambers, Ms. Whitaker's work, review their full file, and hear Ms. Whitaker's testimony. Were you able to do the same thing with Officer Belcher?
Yes, I was.
And did you review a report that he created that was titled Trajectory Report?
Yes, I did.
Did you also review his full case file?
I do know that I reviewed photographs and worksheets from him that would be part of that case file.
The bullet defect worksheets and a few other worksheets like that.
That is correct.
I want to, well, the jury has seen Officer Belcher's trajectory report. That's in evidence. And I want to ask you some questions about some of his findings. Now, Officer, and you were able to hear and see Officer Belcher testify as well, is that right?
Yes, I was.
Okay. He described for us the Faro scan process and the process of placing these trajectory rods to help him calculate these angles. Is that generally the process that is followed, that you are training other folks to follow?
Yes, it is.
So Officer Belcher did all of that correctly, is that right?
Yes.
Okay. You don't disagree with Officer Belcher's findings generally in his trajectory report?
No, I do not.
Okay. So I want you to tell us a little bit more about how you were able then to take the data that Officer Belcher collected through that Faro scan and use it to reconstruct the shooting.
Sure. So this Faro scanner is essentially another tool in your tool pouch, is how you can think of it. There's multiple ways to measure a trajectory. This is one of the newer ways. And so when you have that, again, with the proper training and the proper experience, you can, again, pull all of those data points in from various aspects of the case, depending on the question at hand, and begin to figure out what type of scenario or situation or order of events could have occurred that would have led to the evidence as it was collected, photographed, and preserved.
And as you mentioned, you don't disagree with Officer Belcher's conclusions on the angles that he found after you did the same or similar testing, right?
That's correct. I do not disagree.
All right. Now, Officer Belcher analyzed only defects 1, 4, and 5. So I want to start with those. And I've actually tried to consolidate them here instead of doing multiple pages on the overhead. Does this appear to be an accurate summary? And just for reference, these boxes came from the bottom box here on each page of this report. Does that appear to be an accurate sort of compilation of those angles?
Yes, this is a typical Faro trajectory report.
Okay. So I want to talk first about the inclination angle. And as we learned from Officer Belcher, and as you just reminded us, that is the angle that tells us whether the shot is coming from the top, going upwards. Actually, why don't I just ask you, what does that tell us?
So the inclination angle that Faro has labeled here is what we would call the vertical angle, or the vertical component of a trajectory. And that is essentially that particular trajectory with respect to gravity. So is it an upward shot or a downward shot?
Okay. And then the azimuth angle or the horizontal angle tells us what?
So the azimuth angle, again, is that horizontal angle that says is the shot coming from the left or coming from the right.
Okay. And so we are all sort of doing this together. What I'm going to do here is try to put these angles exactly where they belong in which defect. So defect 1, the inclination angle is negative 10.94. Is that correct?
Yes, that is correct.
And the inclination angle on defect 4, which would be this one, is negative 10.81. Is that right?
Yes.
And then the inclination angle on D5 is negative 16.30. Is that right?
That's correct.
And then on D6, negative 15.46.
Correct.
And remind us what the error cone tells us.
So the error cone is essentially an established field accepted error rate of a trajectory analysis of plus or minus 5 degrees in either the vertical or in both the vertical and the azimuth directions.
And so with that error rate, what does this vertical angle, the difference in this vertical angle tell you?
Sure. So within the error rate, you cannot say that there's a difference between any of these. So for all intents and purposes within that error, all 4 of these trajectories are of the same vertical angle.
And what does that tell you, other than this, the same vertical angle, what does that tell you sort of scientifically about what occurred in this shooting?
So again, that goes back to, with respect to height, there's no change from the shooter to the target. So from essentially going back to extrapolating that to a shooter's position, hanging out the window or moving to get out of the window, all of that would change that height and therefore the height of the firearm. And then that would of course change the vertical angle of that particular trajectory. So if they're all coming from the same angle, again, thinking back to the quick time frame that this could potentially have occurred in, is more consistent with a stationary arm or stationary firearm, excuse me, as it moves past the vehicle, and that the arm or the shooter itself is not changing as it drives past.
Now I want to talk about the azimuth angle and do the same thing. So on D1, our azimuth angle is 83.31. On D4, our azimuth angle is negative 56.64. On D5, we've got negative 77.22. Are those 3? Am I writing those 3 down right?
Yes.
Okay. And then when we get to D6, we talked with Officer Belcher about the fact that angle is substantially different. Why is that angle different in his calculations?
Sure. So on the Faro report, in order to have the software calculate these angles for you, it has to do so with respect to a reference plane. So if you think about, and Faro calls it the impact plane. So if you think about taking a sheet of paper and essentially putting it over the bullet defect, you are then measuring all of your angles off of that piece of paper being your flat plane. And so what he has done here, and it's very difficult to see, but if you have the report in person and you look, you'll see there's a very, very faint black line running right here, here, and then here. And so the reason that D6 is different is because that trajectory from the bumper, that impact plane has been rotated because now he's measuring it with respect to the front of the vehicle as opposed to with respect from the side of the vehicle. And so that's what's essentially called a complementary angle. So if you were to take that D6 front bumper impact plane and rotate it 90 degrees so that it's the same, comparing apples to apples as the other 3 that were measured, that would essentially give you 90 degrees minus his number of 39.55.
And so that would give us 50.45?
That is correct.
50.45, is that right?
That is correct.
Okay. And so what you're saying is that D6 here is measured against this plane, as opposed to this one, is that right?
That is correct, yes.
And so we get negative 50.45 by rotating this plane 90 degrees this way. So
That is
we're
correct.
bringing it out here. Okay. What do the azimuth angles tell you about how the shooting occurred?
So an azimuth angle of 90 degrees would essentially be what's called an orthogonal shot. So that means there's no directionality from left to right or right to left. And so you look at the distance. Distance is not a good term. The numerical value, how far away is it from 90? And so if we look in this particular case, you actually see a progression that matches up with its location on the vehicle. So D1 in the rear driver's side door is 83.31. So only, roughly, let's say 7 degrees off of that 90 degrees. And then you get a negative 77.22. So again, roughly 13 degrees, let's say. Then you have 56, and then you have 50. And so you can almost see that's what I described about relative motion. So the only way that you get angles changing from back to front to back is if there's motion of that firearm that causes those different trajectories. So that essentially gives you, knowing that there was motion involved, it gives you almost an order of shots from D1 to, I believe, what is labeled as D4 and then 5, or 5 and then 4, excuse me. So the into the vehicle engine compartment and then into the wheel well, with the last one being D6 into the front bumper.
So your opinion is the order of shots, D1 is the first shot?
Yes, that is correct.
And D6 is the last shot?
That is correct.
And would your opinion be then can you tell whether D5 or D4 occurs before one another?
No, you can't, again, because we're talking about within the error that's present, that plus or minus 5 degrees, and also the type of surface and the impact plane may vary a little bit depending on how curved that surface is. You can't specifically say which one of those two would have come first.
Now, Dr. Warren, you told us you listened to Officer Belcher's testimony. Officer Belcher told us he did not do an analysis of defect 2 and 3. And in fact, he said it would be irresponsible to calculate defect 2 because he didn't have endpoints for those bullets. Do you agree with him on that?
With what data he might have had, that could be potentially true, but with the data that I was provided, it would not be irresponsible at all. It's actually common practice in order to use another data point such as the medical examiner's report to continue that trajectory.
Then how would you be able to use the medical examiner's report to continue the trajectory if you were not able to either take measurements or examine or in any way, I mean, there's no photographs of Ms. Kaufman's body in the car. How are you able to make that determination?
Sure. So again, this goes back to some of the logic that I mentioned, the problem-solving skills that I mentioned on the front end being as a part of the shooting incident reconstruction. So if we have a trajectory and a bullet that is recovered that is associated with D1 from the front passenger seat, and we have bullet fragments and fragments, basically essentially all of the defects are accounted for in the bullet trajectory except for what would be D2. And so therefore, D2 would be the one that is related to that fatal shot that passed through Ms. Kaufman. So we now have a relation, a connection between the bullet defect in the front driver window, which is labeled as D2, and the trajectory described by the medical examiner in her body. And so you can therefore place, you know only the location, you don't know the angles of a trajectory from the hole in the glass, but we can calculate a trajectory through the body. And so we know that those two have to line up. So essentially that becomes 2 data points, a single point at the glass and then multiple points as the bullet trajectory is described through her body, and those two must line up.
And what about D3? Would you have been able to calculate an angle from D3?
So yes, with D3, again, this would be a situation where you would increase that error cone from 5 degrees. You may go out to plus or minus 10 degrees. partly, as Mr. Belcher described, because of deflection of the bullet. As it struck that hard A-pillar metal, it did begin to deflect. That would affect more the vertical component than the horizontal component, because you can actually see the damage to the underside of the A-pillar and to the front windshield, where the force of that strike carried through to that window. So you can still connect those dots, again, virtually. That's the beauty of having a FARO-scan station, or excuse me, FARO-scan data, this 3D data, is that you don't physically need to insert a trajectory route anymore. You can take that measurement based on the visual defects that you see and calculate that.
When you calculated defect 2 and defect 3, were those calculations consistent with the angles you found in defects 1 and 4, 5, and 6?
Yes, they were.
And I'm not going to ask you for those specific numbers. I want us to rely on what Officer Belcher actually produced. But was there anything about those calculations that you did that made you think, change your opinion about how the shooting occurred?
No, they were not.
Okay. So just specifically relying on these 4 defects, I want to talk, well, we already talked about the order of shots. Make sure we're on track. These 4 shots that we see, or these angles that we see, we know that those occurred while the vehicle was traveling at highway speeds. Is there anything about the fact that the vehicles are traveling 70 miles an hour or so that would impact their trajectories that we see here?
No, there would not be.
And why not?
So the velocity or the speed of a bullet is so much greater than the 70 mile an hour speed of the vehicle that for all intents and purposes, it doesn't care. The bullet doesn't see that speed difference. It's so vast. And in addition to that, the rough distances we're talking about for, I believe Mr. Belcher described a 12-foot wide lane. So a typical 9mm bullet, it travels, again, this is average, 1,200 feet per second, which is roughly 840 miles per hour, and it would cover that 12 feet in approximately 100th of a second. So the bullet itself also happens extremely fast and does not, and happens over such a short distance that it would not be affected by any speed or air or anything of that nature.
So even though, as I think about traveling down highway speeds and I put my hand out the window and it sort of blows it around, it doesn't impact a bullet in the same way.
No, and again, the example of the hand is what's called surface area. It's going to be so much larger than the bullet that you actually do feel the resistance of the wind on your hand. But if you think about something the size of your pinky and were to stick it out, you would feel the wind, but it wouldn't necessarily move your pinky around.
Now, the police recovered 3 cartridge casings from the emergency lane on the very right side of the interstate. Did you see a crime scene diagram that showed the location of those cartridge casings?
Yes, I did.
So you're familiar with the fact that those casings are found many, many feet behind where Ms. Kaufman's vehicle comes to rest?
Yes, I'm aware of that.
And you're aware that those casings there's 2 sort of closer together and there's 1 pretty far away?
Yes, that is correct.
Okay. Does that information change anything about your opinion related to how fast the shots could have occurred?
No, it does not.
Why not?
So a cartridge case is very lightweight, and if it lands on a busy street such as an interstate, it's a very common occurrence to see evidence come in that has what's called road rash on it. So that those cartridge cases will be all scratched and scuffed up and damaged, and that's from vehicles passing by that knock them down the road and they basically tumble and or get run over when the treads of a tire, causing a lot of cratering and damage and dents onto those cartridge cases. And when that happens, they're going to be distributed along the direction of the interstate by that process.
Could that also be an explanation for why there are only 3 casings when we know 6 shots were fired?
Yes, it could be.
I want to talk now about the change of movement that you told us about. So you told us, in your opinion, there's a change of motion, or there is motion between, relative motion between the vehicles. Is that right?
Yes, relative motion, that is correct.
Okay. And put another way, one vehicle is moving at a different speed than the other. Is that?
That would be a simpler way to say that, yes.
Okay. Relative motion could be one vehicle being stationary and another vehicle driving by.
Yes, that is correct. So one being faster than the other. So whether one is 0 and the other is anything above 0, or one is 70 and the other one is anything above 70, would be essentially the same scenario.
And that's why your opinion is that these cars were not traveling at the same speed down the interstate.
That is correct.
Okay. Can we tell how fast one car was going compared to the other?
No, we cannot.
Why not?
So with one vehicle, we have GPS data every second. With the other vehicle, we do not. And so without some type of data points that would give us an idea of that traveling, we cannot know that.
And even though we have that GPS data that tells us there's about 18 seconds from the time the first shot is fired until the time the car comes to rest, we still can't extrapolate that information.
That is correct.
Can we tell if, let's say that a silver Cadillac is passing on the driver's side of this gray Mazda. Can we tell if the silver Cadillac is speeding up or the gray Mazda is slowing down?
No, so again, either situation or both could happen, and there would still be that change, that relative velocity, so a difference in the speed between the two.
Would there be any way, mathematically or scientifically, to calculate change in speed between the two vehicles?
Again, if we had more data points, it is possible to calculate that, but without the data, as is the case in here, no, you cannot calculate that change.
Dr. Bourne, I want to ask you a few hypothetical questions, and I want you to tell me whether what you reviewed and what you have determined is consistent or inconsistent with these scenarios. If the car from which the gun is being fired is passing the gray Mazda here on the driver's side of the Mazda, is that consistent with the information you've told us?
Yes, it is.
Does that match all the data that you reviewed?
Yes, it is the most consistent scenario with all of the data that I've reviewed.
And in your opinion, if that is the most consistent scenario with the data you reviewed, did that incident happen quickly or slowly?
So again, just based on human ability to squeeze the trigger and fire 6 rounds, based on speed and based on the constant changing azimuth angle, all of those would support the idea that there was that relative motion, and that it would have happened in a very quick manner.
Now, I'm going to change the hypothetical slightly. Same facts, but let's say the person who is shooting the gun is the driver of the gray Cadillac that is passing on the side. Is that consistent with what you reviewed?
No, it would not be.
Why not?
So while that could potentially be represented by the trajectories, again, I'm looking at it in a very holistic manner, looking at the limited universe of all the data in this particular case, and the fact that there are cartridge cases recovered on the interstate that then match the firearm in question. If a driver was shooting, those cartridge cases that are automatically ejected out of the gun would end up in the vehicle, not on the street.
So if the person who is shooting from the passenger side of the passing car, is that consistent with the data you reviewed?
Yes, it would be, as long as their hand is out the window.
Okay. Now, what if the person shooting from the passenger side of the vehicle moves his or her hand or arm to follow the Mazda as it passes? Would that be consistent?
No, because then again, I would expect a change in that vertical angle as they reposition themselves to be able to point towards the vehicle.
I'm going to change the hypothetical slightly. Let's say the other car is approaching the Mazda from behind here, either in the same lane or possibly even in the lane to the right, and has to slam on its brakes and swerve around the Mazda. would that be consistent with the totality of the information that you reviewed?
So the event happening behind the vehicle would not affect my conclusion about everything that happened with the relative motion of it passing the side. So that would be a situation where you can't say whether that happened or not. But again, as long as the situation is still the same as it's overtaking or passing the Mazda, then yes, it would still be consistent with the data.
And as you already told us, the data would be inconsistent with the scenario in which the other vehicle is traveling alongside, attempting to pace or drive at the same time, right?
Correct. So yes, if a vehicle began to overtake and then stopped and basically essentially rode next to that Mazda, that would be inconsistent with the data here.
Have you ever worked a case where you have seen a strike pattern that would be more consistent with that scenario?
Yes, I have.
Can you describe what that shot pattern or strike pattern looks like?
Yes, so if you have no relative motion between the two, so either two stationary vehicles or two vehicles that are moving at the same speed, you end up with all of your azimuth angles being the same because, again, there's essentially no movement between the shooter and the vehicle that's being shot at. So all those horizontal or azimuth angles are the same, and you also get what I would call, so in this case, I would say these defects are laterally distributed from the back of the car back of the vehicle to the front of the vehicle. In this pacing scenario, they would all be distributed in a very small, localized area because, again, there's no movement of the shooter relative to the vehicle.
Are there any other scenarios that would be as likely as the scenario we had talked about the other car driving past?
No, again, with the totality of evidence, this is the scenario that is most consistent with everything.
And in your opinion, I think that the shots being fired quickly as that passing happens, that is consistent, correct?
Yes, it is.
Those are my questions for you, Dr. Warren. Thank you.
Did you have examination? General Moore, do you think that we can do it now? Should we take lunch?
Lunch.
Okay. We're gonna break for lunch, okay? Don't discuss the case with anyone and among yourselves, and we'll be back after lunch.
All rise.
Tim. Oh. 1 o'clock? 1 o'clock. All right, see y'all at 1 o'clock. You're still under oath?
Yes, Your Honor.
So don't discuss the case, but I'll see you back in here at 1 o'clock.
Okay.
Thank you.
Thank you, Your Honor.
Okay, as you just heard there, they are going to take a break for lunch until 1 o'clock, and they will continue with Dr. Eric Warren, not completed yet with his testimony. But obviously the big story of this morning was the testimony that we heard from one of the defendants. He took the stand as we expected, Devontae Hill, and we're going to get into a lot of that. We are also now going to give you a chance to sound off on where things stand. As you know, our Gavel to Gavel coverage continues. We're streaming live on Facebook, on YouTube, at the newschannel5.com. Also, right here on the Plus, we'll get the phone number up. If you want to message us on Facebook at newschannel5.com, I'll try to answer some of your questions that come in there. But really, I'll be curious to hear people's reaction, even though I think I can pretty much predict what it is based on Devontae Hill taking the stand on his own defense. And really, to get an opinion on that right off the top, let's go to legal analyst Nick Leonardo. I'll say this, it was riveting. I sat there, and at some points my jaw dropped. You expect someone to take the stand in their own defense because they hope it will help them. If it's possible, I think he further damaged himself and probably hurt Cowan, the co-defendant.
I mean, I think you're right. This decision whether or not to testify on their own behalf is something that's totally up to the defendant themselves. You heard this morning, Judge Dalton went over with Mr. Cowan about his decision to not testify.
Right.
It's called a Moman hearing, and she was discussing that with him. She told him that he had the right to testify and that he's talked to his attorney, Mr. Munkabo. He's decided that he's not going to take the stand. And so, that's a decision that even if you as defense counsel think they should not, and you really tell them that decision is it's up to them.
Sure.
You can't stop them from doing that. But I think when you and I discussed this, out of all the gavel-to-gavel trials we've covered, all the litigation that I've been involved with in over 20 years, this is probably the worst testimony I've seen where a criminally accused in a case like this is testifying in his own behalf. There just was no remorse. It was very nonchalant. He was very hostile. I mean, of course, Jan Norman was hostile too, but that's her job.
Yep.
But he did not accomplish what he needed to accomplish, and then he opened the door, and the jury found out that he shot his grandmother and a 6-year-old and 12-year-old cousin. I think it was so bad for him. I think that they even bled over onto Cowan.
I think so, because they're cousins, and they're gonna just have distaste for the both of them all the way around. Now, the reason he may have taken the stand, one, maybe to try to possibly connect and curry some sympathy, but we saw no remorse. The other reason was maybe to try to address the issue of premeditation. He was saying that, oh, well, I just reacted in the moment, and just, that would be not premeditated maybe in his mind, whereas the prosecution saying, wait, you fired 6 rounds into this vehicle, you thought about it, you knew it. And again, he's saying, I just wasn't thinking, I was under intoxicants. It startled me when Cowan hit the brake when she cut us off, so I just pulled the gun and started shooting.
Well, I don't think he told the entire truth.
Right, I don't think so either. And so, but I think that's what they were trying to achieve, is trying to address, hey, this wasn't premeditated, he just acted in the heat of the moment. Which technically, if you believe that, could be something less than first-degree murder, correct?
I mean, the jury's got to like these folks.
Well,
the jury's
right. I'm
got
not
to have
saying
a
they're going to do
reason
that,
they
but
wanna-
that's what they're trying to seek, right? To get second-degree murder or something less than first-degree, you have to be convinced that it was an act of passion in the heat of the moment with no forethought, correct?
Of first degree, is that what you just asked?
Yeah, for first degree.
Premeditated, intentional first degree murder. I think we're going to see. I think we're going to see Jan Norman. I think we're going to see the state pull out the murder weapon and go 1, 2, 3, 4. Right?
I agree.
And I tell you, Judge Dalton's done a real good job with this, though. She's, ran a tight ship. And, and again, I think one of the pivotal moments is when they opened the door and then they were able to get into this juvenile conviction. I do want to say again, though, that the judge here, by her going off the bench and saying, I want to make sure I'm making the right decision, that's what every lawyer wants to see. That's what every litigant should want to see. And I think that, the residents of Davidson County are lucky to have somebody who wants to make the right decision all the time, because that right there, that decision was so important, and she took her time to make it. So hats off to her for doing it.
And again, what opened the door was Cowan testifying, under questioning by the defense attorney, saying, well, he fired the shots and he didn't really know if he had hurt someone or something along those lines. And I guess because of that, you can say, well, darn right, if you fire shots, you can hurt someone. And that's where the argument was. Jan, with the jury out, said, look, we know he shot his grandmother as a juvenile along with 2 other family members. He knows exactly what happens when you shoot a gun.
But see, his testimony was inconsistent with that of Gish's. And, and I'm going to accredit Officer Gish's testimony because he has no impotence to really lie. He's got several murder cases and several investigations, and he's just, matter of fact about it. But he said that he did not know that, how did he exactly? He said he did not know that he had killed anybody till he saw some news story. But then yet we heard from Gish that even before the police department knew about the crime, he was Googling to see if that happened. So clearly he was aware.
Yeah, he knew there could have been, someone he killed.
But he just too many holes. I don't know. I wasn't thinking. I was high.
He said
I just
he was
don't
full
remember.
of rage, and it was all about I, me. I'm protecting my family. I'm protecting, and I'm wondering. He talks about his kids. I'm sorry, I don't know. Do you think when he says that, you're wondering what kind of father he is? I mean, it's just talking about family, and we protect the family, and I protect my family, and she's like, well, you're protecting Cowan, aren't you? Because he went out of his way to say Cowan had nothing to do about this, okay? And it surprised him, and I'm wondering if he's telling the whole truth there. I can't help but think when Cowan hit the brakes, at the very least he cursed and said, dang, someone cut me off.
I think he's a product of the juvenile justice system in a lot of ways. That sort of demeanor, I believe, would have worked for the juvenile justice system. them that kind of, hey, I wasn't sure, I was under the influence, I was high, that might have got you out of trouble. But this is the big leagues, okay? And you didn't do enough to get out of trouble today.
Yeah. You made a point. Had it worked the first time around when he did those shootings, Caitlyn Kaufman would still be alive. Had that been transferred at the time to adult court, which it wasn't when he shot his grandmother and the others. I mean, you just wonder, and maybe at the time they thought about rehabilitation, and this is a youngster, he didn't kill anyone. Of course, he said in court that they forgave him, and there's unconditional love there. But it does make you think. I mean, there were certainly red flags on this guy, and if nothing redder than shooting half your family and then still being out there, that he could do this again.
Well, that's exactly what people are going to think, but it shows his immaturity. And again, I call him a kid, he's an adult, but he's still very young, very, very young. And the questions that Jan Norman would ask him would be some sort of compound question, and the things that he should have refuted, he didn't, right? The worst part of her question, he didn't refute. He would refute some underlying, really arbitrary point. And again, he was very argumentative with her. And she was argumentative with him. That's his job. That is her job, rather, I immediately could tell when they opened that door. I heard the Jaws music playing. I knew they were ready for this.
Oh, she was.
And and a lot of people on Facebook said that they thought she was going over the top and doing too much. Look, folks, these individuals have a job to do. These lawyers have a job to do, and you should know that she's a passionate prosecutor. And if you're going to step up on the stand, you better bring it, because she's going to bring it. And she's doing everything she can to pursue the truth and to pursue justice for this family. And she's not going to throw underhanded softballs. My goodness, he didn't even do that hot with his own lawyer.
No, and his lawyers served him up. In fairness, then, let's go to his lawyers, because some people, based on what we're saying here, are saying, well, why on earth did they put him on? I don't know if you agree with me, but I think even before he took the stand, I think that he was done.
Well,
I think the jury's already thought, and it was his decision, but I'm pretty sure that his attorneys agreed or encouraged or said, yeah, I think this is probably good. Look, I don't think his attorney said, no, we don't want you to do that, and he insisted. I don't buy that for a second. I think he listened to their guidance on this.
I don't think Sims and Chafin, listen, these guys are in criminal court every day. They see people every day. They might like him as a person, but I think they practiced this, and I think they looked at each other and said, no. I think they thought, absolutely not.
It'd be interesting to talk to him afterwards. I don't think, based on what I'm looking at him, that he on his own said, both my lawyers are telling me not to do this. No, I'm going to do it. I just don't buy that he has the wherewithal to go that way.
And they're not going to tell you that because it's privileged. And you'll never know the answer to that. But.
Okay, so we disagree. I think that they said, and I agree with them if they went this way. I think he was done even before he did this. And they're like, what do we have to lose? Absolutely nothing. Okay, he may be horrible. Well, it's not going to make it worse than we already are. Let's have him go up there, and maybe he comes off sympathetic to possibly just one or two jurors, and it leads to something. Without that, I'm not saying that, oh boy, he was right on the edge there of maybe getting a lesser charge, and this just ruined him. He was already toast before he testified.
Well, and I think it may have, at first it seemed like he was maybe helping Cowan a little bit, but yeah. I don't think that the jury believed him. All right, you have to, in order for this to help Cowan, you have to believe Hill. Okay, and I just don't know that resonated because people just don't understand. So in other words, you get cut off and you don't know what you were thinking or why you did it, and you were full of rage, and so you shot 6 times, and but there was just no remorse, right? There was literally no remorse. It was about him, and he was offended that you're even asking him that question.
With regard to Cowan, this is interesting. Kate messages on here, and this is something the jury doesn't know. Kate writes, regarding Cowan, if I'm correct that Cowan has no major criminal history at age 28, then I'm inclined to give him the benefit of the doubt that he truly didn't participate in what was all Hill. Now, Cowan did not take the stand. This did not come in. It was actually Hill who, at least as an adult, didn't have serious criminal charges. But Cowan, we know, has a lengthy criminal history. All right, let me just give you an idea. The jury doesn't know this, and you can explain to the viewers why. But he is at this point facing federal gun and drug charges. All right, he was discovered with a substantial amount of Xanax and fentanyl, along with $2,100 in cash.
And that was 2021.
Yep, they found a Glock pistol with an extended magazine and handgun. Prior to that, he had a conviction for robbery in Davidson County and was sentenced to 6 years in prison.
2010.
So Cowan is not some guy who was in this car with him who, I mean, Cowan, I think, has more criminal activity than Hill up until this shooting as an adult.
That's right. The 2010 robbery conviction, 6 years community corrections, and they gave him a chance. They put him on stringent probation. He violated that probation, okay?
Right.
And then they had to go back and do some time. Then in 2016, he gets a new weapons charge. And then in 2021, you have the crook with guns where they have lots of drugs and they're a felon and they have guns. And this was post the Kaufman incident, okay? So the jury doesn't know about these individuals.
See, Kate didn't know that either. And from Kate, and if the jury doesn't know this, if they agree with Kate, maybe they're thinking, well, maybe Cowan isn't as responsible. But why couldn't they be brought in, by the way, what we just described?
They have to, they have the rules of evidence, right? And the Tennessee Rules of Evidence, Rule 609 deals with impeachment. And if they were to take the stand, in this case, the state did file a notice to use these prior convictions, and they were going to ask the defendant about it. So they put the defendant on notice well in advance that they're going to be asking about this if the defendant were to testify on his own behalf. And so under very rare circumstances can some of these convictions be brought in, but it really comes in if the individual takes the stand. And the reason the jury doesn't know these sorts of facts is because it shouldn't be that way. Like, for example, if you're charged with felon in possession of a weapon, you don't have a trial on felon in possession of a weapon. You have a trial on possession of a weapon because the jury's not supposed to know you're a felon.
Right.
Okay?
Right.
And so it's in an effort to get a fair trial to where there's no bias. And the jury is solely focusing on the facts at hand, okay? And that's why they got into this. I mean, if the jury was on the fence, they may have thought, well, maybe yes, maybe no. Then they hear he shot his grandmother, a 6-year-old and a 12-year-old cousin.
Now that they've heard that,
I mean, game over.
Game over. And what you just described there is exactly why Cowan did not take the stand in his own defense. I mean, people might have liked to have heard him come on and say, kind of like Hill did, he surprised me when he did it. It startled me. But if he did that, then there's a potential his criminal charges could have come up. And once the jury hears about his priors, that would have hurt him more than anything he could have gained by going up there and saying he was taken by surprise.
And as a criminal defense attorney, there's a lot of times when you're trying a case and you have co-defendants, you've got somebody that's worse than someone else. And so a lot of times you sit there as a lawyer and you get scared. You're like, I don't want that person's bad stuff rubbing off on my client because my client, has a different role and is not that bad. And clearly, they were hoping that this Hill stuff didn't rub off on Cowan, but I think the way that it came during his testimony that he was trying to take up for Cowan, and I don't think anybody believed him because his memory got better. Cowan didn't say anything. Cowan didn't know, and so who believes that he doesn't know that you're going to do this? You pull out a gun, shoot 6 times, and he doesn't look back at you and say, "What the heck are you doing?" Like what? He didn't say anything.
Right.
Get out of here.
Yeah.
Nobody believes it.
Right. You're exactly right. It's sometimes you just don't check your common sense at the door.
That's exactly right.
And these jurors won't. Let's see what some of our viewers think. Following on Facebook, they're on a lunch break. They'll be back. By the way, real quickly, some of the people on Facebook were asking how long do we think this will go tonight or today. They've taken the lunch break. They'll come back. They'll finish up with Eric Warren. Okay. I think that's their last witness. They'll rest. What do you suspect? We know they don't have, court on Sundays. So will the judge say, hey, let's go and see if we can get a verdict today? Or do you think that she might say, or ask them, do you want to come back on Monday?
So we heard, I guess, a couple of days ago, Judge Dalton gives deference to these jurors, okay? And so she doesn't want to overwork them, but, she wants to let them know that they are kind of the captain of the ship, as it pertains to the schedule in accordance with, what she has to get into evidence. And so if the juror, there was one juror that had something that they had to do this afternoon. So
maybe she's going, and she even said yesterday,
it's not
I'll try
all day.
To get you out before that so you can go. So maybe that's still on the table, and she may just wrap things up today after this last witness.
And come back and then on Monday and do closing and charge them. However, if that juror no longer has that commitment, and those jurors are like, yeah, I mean, let's go ahead and closing arguments are going to take a couple of hours and read the charge. We don't want to come back. Let's go ahead and handle this today. I think the judge would absolutely move on. No doubt.
So, and I think you and I are both in agreement, at least with regard to Hill, the jury deliberation shouldn't take more than 10 minutes. And I know it'll take more than that, but that's a no-brainer. Maybe more debate back there somehow when it comes to Cowan. Because seriously, if this jury has questions about Hill, I got a problem with this jury. Well, that's a no-brainer. That should come back so fast, it's crazy.
All they have is the TBI
Cowan
agent. That's all they really got. Because if you don't believe Odom and you don't believe Hill, okay, then who do you really have that's really pointing much at Cowan, right?
So maybe there's more of a debate about Cowan's fate, but in my mind, if I'm on that jury, there is no debate on Hill. Let's go to Katie. Katie, good afternoon. Hi, Katie.
Hi, how are you?
Good. What's on your mind?
Well, I am so with y'all on this whole thing about Cowan. I think Hill is guilty as sin. I mean, it's a no-brainer. I agree with you 1,000% on that. I mean, he did it, and he did it when he was 16 years old too,
Yeah.
and he shot up his family. That's the way I feel about so many people that are out there doing crimes. There are kids out there doing big boy crimes. They're getting little boy sentences, and they come back as big boys, and they do big boy crimes all over again. They do big boy crimes on their kids too. I think we need to take care of that. That needs to be changed in our justice system. I think that somebody's 16 years old and they have the wherewithal to pull a gun and shoot 3 members of his family. Come on, guys, come on.
Yeah, that's fairly extreme. You even said, Nick, I mean, who knows? Do the lawmakers, and that's where it starts, legislatures
Caitlyn
redoing
Kaufman's,
it.
law, because there's a rule about transfer hearing. There's rules about what the alleged offense is, the age of the minor, and whether something like that would be mandatorily transferred to adult court, or whether it's discretionary with the judge, and they have a big drawn-out hearing to determine whether or not that minor gets transferred
Isn't
into
it
adult
all
court.
discretionary? Is there anything that, I mean, you would think, obviously, first-degree murder automatically, but still it all goes and has to be transferred by a judge, doesn't it?
And
the juvenile court judge.
And the district attorney has to push for that transfer, so it's not solely on the juvenile court judge. A lot of times the district attorney's office would agree.
That's right. Yeah.
And so I do want to underscore that, I understand if I was a Kaufman family, I'd be mad at the fact that this kid's still out here, okay? Because my daughter would be alive. But for every kid like Hill that gets an opportunity, and a heck of an opportunity, I might add, with that set of facts, and is not transferred to adult court, and then comes off and does this, and really gives a bad name to everybody that gets a second chance. But for every Hill, you're going to have 100 more, young kids that really that second chance made a difference in their life.
Exactly.
So it's not just all negative, okay? But one instance like this really is negative. And it makes
I'm glad
everything
you
look
said
bad.
that. I mean, there are a lot of cases. It's just when it happens like this, it's just so devastating, just absolutely devastating.
Well,
the nature of
and
this
how do you
crime.
think the players who made the decision to not transfer feel?
All right, let's go to Ann. Ann, good morning or good afternoon now. Hi, Ann.
Good afternoon. I'll try and be quick. This morning, I noticed a cell phone in a shirt pocket of one of the defendants. And it shortly left the pocket not long afterwards. And then when they went to break and they came back, it was never seen again. And it made me wonder, are these two defendants allowed to be communicating? Because at the end of Detective Valley yesterday, my first thought when they took that long recess is they're trying to decide which one of these two defendants is going to testify tomorrow. And luckily, Hill, I think, put the nail in the coffin for both defendants. But have they been able to communicate with each other the whole time they've been in jail?
Hey, how do you know it was a cell phone? Did it just look like it?
It was sticking. Oh yeah, it was sticking out of the pocket, and
Okay.
at some point they started conversing with their attorney. And about 15 minutes later, I noticed that cell phone that had been sticking out of the pocket was no longer gone. And today, neither one of them are wearing suit coats, so it stuck out. And maybe I missed it. I know General Norman said he had shot 3 times and injured multiple people, but I don't think I heard her at that time say the ages. And my thought was, she's going to slam them with closing arguments. So she was not restricted from telling the jury the ages, correct? And lastly, and this is just for fun, because Channel 5, I've taken a lot of ribbing. Mr. Leonardo, I am a Father Ryan graduate. I pass your office all the time. I've gone to Holy Name since 1970. If you ever want a free research analyst, just hit me up. I'll come and comb your book.
Well, I'll probably know who you are, Ann, because I used to go to church over there some mornings at 8. They had mass, and it's right next door. So I probably know who you are and just haven't put it together. So if you see me, Ann, please say something to me. Stop by the office if you're over there.
That's That's very cool. What about that? If that's true, that he had a cell phone, I can't imagine in the courtroom.
No.
Would there be a circumstance where they could have one?
No. So I mean, clearly, I think their lawyers have maybe videotaped interrogations or other videos, and they're trying to, so you might just hand him, look, listen to this video, listen to yourself, right? And so they may, be using the lawyer's cell phone to review some of this evidence, okay? But clearly they don't have cell phones. They're not allowed to have cell phones. Now, I will say that at the Tennessee Department of Corrections, I do have inmates, clients in the past that have had cell phones, but not in Darren Hall. I mean, it's probably very rare at Darren Hall's jail to have that. But if they had the cell phone, it belonged to one of the lawyers, and the lawyer was giving that to them so that they could, prepare for trial or watch some video or something.
One of the viewers on Facebook says, who rolled down the window on the Cadillac? I think we heard Hill testify that they were smoking in that car big time, and they rolled down the window, and I took it that he rolled it down because they were wondering.
Well, he doesn't remember where he was seated during this either. You remember? He said he didn't know where he was seated. Hill did. He said, well, where were you in the car? I don't remember is what he said.
Oh, yeah. But, okay, yeah.
But his memory got better as they went.
But yeah, I thought Jan Norman did a nice job. He didn't remember anything that Cowan said, right after that happened, but he did remember what Cowan said later. Selective memory, and clearly it appears as though he's trying to protect his friend. That's the way I would take it. Now, what his friend said, I don't know. But,
well, and clearly he's offended that Jan Norman wants to ask him questions.
I guess.
I mean, did you not see the attitude? There was a little bit of attitude.
Yeah, I think this is an individual going back to his juvenile times that has rage and anger issues, and I do believe he will fly off the handle. And you and I were both sitting here waiting to see him really lose it.
I thought he would too.
I think Jan, that was part of her act, because if she could get him to completely lose it in the courtroom, then that's all she wrote too. It's all she wrote anyway, in my opinion. But I was waiting for him to lose his temper, because I don't think this guy is very good at controlling his emotions.
So, I just had a deposition yesterday, and I did this yesterday. If I know that I can get under your skin on cross-examination, then I'm not going to let up. I'm like a dog. I'm not going to turn loose of it, right? But if after 5 minutes, if I realize that what I say is not going to get under your skin and you're doing a good job, then we just move on, right? But clearly that's what lawyers do.
You can tell when it starts going that way. Let's go next to, I believe, Linda. Hi, Linda. Good morning, or good afternoon, Linda.
Good morning.
Hey.
First of all, I thought that defendant had no remorse at all. In fact, less than any. And why was he so protective of Cowan? Do you think he's afraid of getting executed in prison by some of the gang members? I mean, half his testimony was to defend Cowan.
What do you think? That's a good question. I'm just wondering, the motive behind him going out of his way to try to say that Cowan had nothing to do with it. Is it because this is a cousin and he cares about him and he's going to go that way? He's got nothing. I don't think he's afraid of anything. I don't think. Why do you think? I mean, if you don't believe him, because I'm like, maybe he's telling the truth here. And Cowan really didn't do anything, at least to encourage. Certainly after the fact, he tried to cover it up.
I mean, I do think there may be some truth there. I mean, I do think Mr. Hill probably does feel bad. I don't know that Cowan, really knew what his intentions were. Okay, but at the point in time, once he starts shooting, then it's back on Cowan as to how he's going to handle it.
Yeah.
I mean, really it is. And so there's probably a bit of truth there to that.
Okay, let's go next to Judy. Judy, good afternoon. Hi, Judy.
Hey,
what's that?
I have a comment. I was just a little disappointed in the judge as her being a attorney before she was a judge when she interrupted the prosecutor's rhythm in his no doubt in what he had planned to say by calling lunch.
By calling lunch?
I said, sometimes the rhythm kind of gets interrupted, and I also wanted to say, with the driver, why isn't he considered an accessory?
He is. That's why he's charged.
He is. He is charged with first-degree murder as well.
That's right.
What about her point on rhythm? I mean, yes, I know the judge is concerned with getting them to their lunch, and it was after 12 before she broke. Is there anything to that a lawyer gets going on a stream of questions and maybe objections, or a judge calling a pause breaks that concentration?
The last thing I would say is that, I mean, and Judy's entitled to her opinion, I have zero disappointment with Judge Dalton, okay? I mean, how many times have we seen a judge get off the bench and say, let me double check, I want to make the right call? We never see that here, right? It's just shooting from the hip half the time. And some of them are good and they know their stuff, but so I don't think so. But you got to understand what that judge is under. That judge orders a lunch and trying to anticipate when there would be a break in testimony, and you don't want lunch to get cold or whatever. And so, you do that, and then somebody opens the door, things take longer than expected. So she's trying to find a good spot in which to break for lunch because the jurors need to eat, and they've been sitting there for a couple of hours. And so it looks as though she's broke. I think they're ready for cross-examination, I believe. So she broke in between, the testimony, and she really had no choice because cross-examination could go for another hour, it could go for 10 minutes, and of course the state really doesn't know because they don't know what they're going to necessarily say. If they had no cross, I'm sure they would have told the judge that. But again, the judge is listening because that's the job. She's got to take notes because this is going to come back again because there's going to be a conviction, and then she's trying to orchestrate what's going on in the courtroom with the staff and the witnesses, and she's responsible first and foremost for these 14 people that have to go to the bathroom and are hungry.
Yep.
And so I think she's doing a great job of juggling all of this because remember, it's more than just logistics. She's the judge, and so there's so much to keep up with.
Point taken. Let's go next to Miss Johnson, I believe, on line 6. Hi, Miss Johnson.
Hey, thanks for taking my call.
Sure.
The reason I called, y'all really touched on everything that I was going to say as far as Hill, that his demeanor is horrible. Oh my word! And I hope the jury took notice of that. And he has no remorse. People have said that, but another thing that I thought of yesterday, and it just really, really touched my heart. Ms. Kaufman was a nurse, and she was going to help, the COVID patients or whatever. And even before her death, right? When she was still driving, she still saved lives because she was able to she had it in her mind to pull over to the side that she wouldn't wreck into anybody else on the interstate with her.
Yep.
And I said, Lord, even at the end, she was still saving lives.
I agree.
And
yeah.
It just really touched my heart when I thought about that. I said, Lord, but I really hope that the jury really pays attention. I mean, I know they do, don't get me wrong, but I'm saying to get this right, and both of them need to go to prison,
Thank you. Yeah, I felt the same thing. It hit me again when the testimony came yesterday, again, reminding us all that when they found her vehicle 2 hours after she was shot, remember it didn't happen initially, the car was still running on the shoulder, and her foot, she was deceased at this point, but her foot was on the brake, and she was shot on the road. She didn't know she was mortally wounded in that instant. She knew it was bad, but she knew to get it over the shoulder, she didn't lose control of the car, and she died with her foot on the brake to make sure the car didn't, who knows really what was going through her mind, but that's how I took it. And that's, I'm glad too, we talk so much about these witnesses, you get into the trial and the lawyers and the defendants. This case is about one person and
That's
one
right.
person
That's
only,
exactly
and
right.
it's Caitlyn Kaufman, a person who died under unimaginable circumstances that should never ever be forgotten, and it's all about the victim. She is the number one person in this trial, and you do sometimes lose track. Well, what about Hill? What about Cowan? Then you get to know the attorneys. It's all about Caitlyn Kaufman and never forgetting it, and that's a good call.
And that's exactly what the closing arguments are going to be about, because I think I know I've gotten lost in that to some degree.
You can, in day after day of trial, and you just can't lose sight of that.
And that's what they're there for. They're there to tell her story as the victim. And I think that and now there's even more impetus than ever because of Mr. Hill's testimony that it's not about Mr. Hill, it's not about Mr. Hill's family, it's not about Mr. Hill's feelings, it's not about Mr. Hill coping. We're here because he killed her.
That's right. Enough said. Let's go next to Mary on line 7. Mary, good afternoon. Hi, Mary.
Hi. Can I first start off by saying my heart goes out to Caitlyn and to her family. This was just a horrible, horrible thing to have happened. But I have a different perspective because I am black, and I know the struggles of some black young men. And these are very young men. They're street men, very young men. And what he did when he was 16 years old. You don't know the background of that. That should have never been put in there against him as an adult. These kids that go around here shooting up the whole schools and killing everybody in their school, they don't treat them like that. And what I really, I have no faith in our judicial system because, like the commentator said, he's already convicted before he's even on the stand. He has a right to tell his story. And his story is that the other boy didn't have nothing to do with it. Let him tell his truth. The other boy didn't have nothing to do with it. The boy wouldn't say that. He's not scared of that boy. The boy didn't have nothing to do with it. That boy has anger issues.
No question about it. Listen, there are plenty of people who are saying, why do we even go to trial on this one? Okay, I mean, with the evidence and the way it is, the reason we're going to trial, Mary, is because both these defendants have a right to a trial. They could have said, we'll plead guilty right now to life in prison. Why would you do that? He has a chance to tell his story and get up there. And he has. And that's his time where he gets to say his piece. But to say that, you know, youngsters that have these problems in their lives growing up, not all of them shoot 3 members of their family and then murder someone on the interstate. I'm sorry. That just your past background doesn't instantly, even with hardship, and I have no doubt he probably has a hard family life growing up, but that doesn't give you license to say it was a tough life. I'm going to murder someone and shoot my family.
Well, and I am sensitive to what Mary says about that, and she's, you know, she makes a point, but I will say, you know, like in family court, divorce court, and like that, and those kinds of courts, they do have days where they do happy stuff. They do adoptions, right? Yeah. And they do that, I believe, on Tuesdays a couple times a month, and that's one time that you get to see something happy happen in the family courts. But in the Birch building, you know, it's kind of 3D, death, doom, and destruction. There's not a lot of happy things that happen in the Birch building. I mean, here they have a family that's lost Caitlyn Kaufman. Okay, and if these 2 individuals are convicted and go to prison for life, then you have 2 other sets of families that are absolutely devastated, that didn't do anything, that have also lost a loved one. And hearing Mr. Hill, a child that may have lose a father. Yeah, I think so it's tragedy all the way around sometimes in these cases. You know, I mean, it really is, because, you know, no matter what verdict comes back, Caitlyn Kaufman's gone, and nothing's going to change that. Right.
And what I come back from with Hill too is just the word comes to mind, senseless. Completely senseless. As we talked about, was he maybe thinking that was a gang member in the other car? Was there some kind of realistic maybe motive somehow? He thought, I'm going to get this person because they were trying. No, this is just senseless. Even he said as much. He was reckless of me. I don't know what I was thinking. It was in the heat of the moment is what he said. And just did this. Completely senseless. He didn't know Caitlyn Kaufman. And that's the other scary thing about this, I think, for all of us as we watch this. It happened to Caitlyn Kaufman, who did not know these 2 people. That could have happened to any one of us.
I thought about that this morning.
Second. Any one of us could have been susceptible to that. There is absolutely nothing she did to bring this upon her except drive to work. Period. And you even heard Hill say he doesn't think she was even aware.
She was. I remember.
Yeah, she wasn't even aware. He doesn't think that she cut him off. So she probably didn't even know. And who's to say if she really did cut him off?
Well, but here's the other thing. If you say that she was not aware,
how do you know?
How do you know that she wasn't aware? If you said just the very next statement that you didn't know that there was a female driving the vehicle. See, you can't have it both ways.
Yeah, these little things.
You can't have it both ways.
Right. All right. We will go next to, I believe, Amand on 10. Amand, are you there?
Yes, sir.
Hey, go ahead, sir.
I just want to say right there that my sister-in-law got shot 2 years ago right there in Nashville in J.C. King Homes on Murfreesboro Road. They still letting her kill her right there and walk around right there until he's ready for court. And I just don't understand that.
Huh.
But my another point is right there, if they got cell phones that's got GPS tracking device, why can't they put that in guns?
GPS is in guns. I don't know.
It's because of certain legislators and certain amendments and certain politics associated with it.
Right. As far as accused killers being out on bond, it sounds to me like he's describing a situation where there's someone out. Okay, if you're accused of your first-degree murder, you can get a bond. By the way, there was no bond on these 2, and even had there been, they don't have the money to post it. But what circumstance can someone accused of murder get out?
Well, in every circumstance, bond is a constitutional right that's guaranteed by the United States and the state's constitution.
Except in capital cases.
Except in capital cases, which means the state's officially going for the death penalty. So, so the question is what's the amount of bond going to be? 4011, 115, I believe, are the bond statutes, or 118. And they list factors that the court has to consider to determine when they should set a reasonable bond and what that amount should be. And the amount of bond is solely there to secure one's appearance in court, okay? Not punitive in nature or anything of that nature, anything like that. And we actually have just had an overhaul of a lot of our criminal justice laws, including the bond statute, July before last, with an increased sensitivity to mental health issues and other kinds of drug issues, addiction issues, and could they be treated and handled better on the outside versus the inside. And the most important thing from my perspective as a judge, if I was sitting there, would be the conditions that you place on the bond. Not so much how much it is, but the conditions of, whether it be electronic monitoring, whether it be you can't go around the victim, whether it be a particular curfew, forfeit your passport, and then if those conditions are violated, then you don't feel bad about locking that individual up. But everyone's entitled to a bond, as we saw with the 5 Memphis police officers who are now out on bond.
Yep. If you can afford it, if you can make it.
You can make it.
You can. All right, let's go next to Frank. Frank, good afternoon. Hi, Frank.
Hi. First of all, thank you for coverage.
Sure.
And my question is, I only tuned in a little while ago, but I don't know the names, but the shooter was describing the uninvolvement of the driver. And I thought, as we were hearing the data support from the expert witness consultant, and there's science and math involved and so on, and so those angles and all that has to do with, it wasn't just somebody holding a gun, but somebody assisting in getting the kind of kill angles or damage angles. Having to control that car becomes a deadly weapon, armed with a killing machine, a gun. And so in combination, the two are equally guilty, without a doubt in my mind.
I haven't considered that. That's a good point by Frank. The state could get up and argue about those cones that we heard. That they could get up and say, well, somebody had to keep the car level, there with it so that they could do it. Someone had to effectuate getting that person in position.
What this witness is talking about. Eric Warren is trying to make the case on bullet trajectory and stuff to contradict some of what the prosecution's witness had said, because it sure seems to me like, especially the kill shot, they were going 70 miles an hour and they had to be pretty much parallel for Hill to shoot out the window and hit her in the shoulder, which then, of course, tore through her body.
And one of the things I wish that they would do, is on these experts, a lot of times they take so long. I mean, Gish is full of stuff. He can't just, but this particular expert, Warren, why don't you ask him at the very beginning, now, you're here and you anticipate testifying to what? And let him just go ahead and tell you the overall issue, and then let's get all into the fancy math and physics of it all, and then we can wrap it up and come back. But I think a lot of times folks are wondering, well, I wonder why why are we seeing this, right? And so I think that could be helpful, to just kind of tell them on the front end, this is what we're going to testify
I wish they would do that in all trials. I can tell you how many trials we've done and that I've covered outside of gavel to gavel, where I hear some lawyer going with something and I really don't get an explanation of where he's taking me.
Until closing.
And then I think, oh, it'll come up in closing. And I'm listening, and it doesn't come up in closing. So I'm thinking, they were just wasting my time. And I do think sometimes lawyers throw stuff out there, if for no other reason, maybe to confuse the matter. But that's happened before. I'm like, okay, I'm sure they'll explain later in closing and wrap it up. More times than I can count, I don't hear it in closing. I'm like, why the heck did they bring it up in the first place if they're not telling me why?
I would have asked, I don't think, and maybe I missed this, I don't think I did, but if I was Jan Norman, I would have asked Mr. Hill about the Cadillac and about burning it. Did she get into that?
Nope.
See, I thought that would have been another opportunity there.
No. Yeah, the last thing she really touched on before she, I think pretty abruptly, and could have gone on longer, was about the shooting involving his family. And that was it.
I think
she got that in, and that was it.
Roger got the cane and was like, that's enough. You've made your point. You've made your points. Let's move on.
That might be the case. All right, we'll go next to, I think, Bonnie. Bonnie, go ahead, Bonnie.
Hey, Nick.
Hey.
Something I wanted to say that I observed in Hill's testimony there was he was trying to lay blame on Odom, that Odom is the one that asked for the gun, when in fact he had already asked other people to take the gun and get rid of it. I think he was trying to throw Odom under the bus because he was mad because he was had turned him in. What do you think about that?
I think you're right about that, Bonnie. I noticed that there was a lot of angst that he had towards Mr. Odom, and like he wanted to get up there and try to discredit Mr. Odom. And I got to thinking, buddy, that's not your problem.
No,
your problem is not Mr. Odom's credibility. Like, you need to be focused on the remorseful aspect of your actions. A different demeanor. But I saw him kind of go after Odom.
Well, he contradicted Odom, but I'm not sure in the big picture what it
here
means.
comes the judge.
See. Jury coming back. Let's listen
This is
in.
going to be a scheduling
Afternoon
conversation.
session, maybe on scheduling.
I see you back here today. What you doing here today? Okay. All right. Yeah.
Quiet, please. Quiet, please.
I don't think we can. I don't think 6 feet.
All right, looks like they're back in all together, and they have something they need to address on a sidebar.
Yeah,
here.
the jury's not in the courtroom, so if it wasn't for the TV camera, they probably wouldn't necessarily have a sidebar. But I think the judge is probably trying to, get at where we are. How long do you think your cross is going to be? Y'all think you have any more witnesses? How long do y'all think for opening or closing arguments? Rather, trying to get it, or maybe she's heard back from her court officers that the jury wants to go forward today. So she's talking about the schedule.
Do you think the court officer was in there during lunch saying, well, how are you feeling? What are you guys thinking about moving
the
forward?
court officer has to be in there because, or at least right outside the door.
Make sure they're not talking
making sure
about
they're not
stuff,
talking
yeah.
about it, so.
But would he maybe go in and say, hey, listen, it's Saturday.
The judge wants to know,
Yeah.
what are you guys thinking? You guys want to break today, come back on Monday? Do y'all want to plow on through? What are you thinking? And then they'll let the judge know. Then the judge would bring them back out after they confer with lawyers and let them know. And we would hear that.
Right.
That's my understanding. You'd like to break today or you'd like to go forward.
Yeah. It's interesting here, though, by the way, as I'm looking at the monitor in there, it appeared, and I think Rick said the same thing, that there was something said about the camera. Usually we're showing them up there in sidebar, not hearing, but showing. But the camera panned over. Is there something they don't want us to see over there on the left-hand side right now? Which I can't imagine what that might be.
No,
but I'm not sure why we're taking this
think
shot.
The judge was making, just joking around with the camera person as she does every day.
Yeah. Well, her favorite camera person is Bud Nelson.
Well,
but he's off on the weekends.
Catherine's running a close second.
Catherine is right there, and Jim Garby's in there now for us. And our pool camera has done a terrific job.
Well, Bud will have to take her lunch or something one day. I'm sure she'd like that.
But the pool camera, by the way, there's one photographer in there. When we say pool, that means all the stations, of course, are covering this trial. And there's a box outside the courtroom where everyone plugs in their recorders. So everyone, us, all the other stations in town, have equal access to the audio and video from the courtroom. And when there's just the one camera in there that feeds it, and we, News Channel 5, happen to be the station with control of that.
I think it's more an affinity for Bud.
Who knows? There goes Jan Norman stepping out. And again, there are reporters. We have a reporter there today, Aaron Cantrell. All the stations have reporters. They can sit in the courtroom along with anyone else in the gallery or outside and monitor everything that comes over the editing machines. That's kind of how it's set up. The only thing that court photographer can't do is show the jury, which is to his immediate left. That's a hard and fast rule that we're not to show the jury.
And the judge has that computer up there, and that's how, a lot of times they run things. That's how she communicates with the secretary about, the lunches are here, they're not here, or if she needs something, she can't just run off the bench. She's got to.
Right. So that way she can do that.
Yeah.
Well, of course, General.
And to her right is the clerk, who is Miss Wise, and I'd hate to say how long Miss Wise has been there, but Miss Wise is she's been there. I know maybe 3 judges, and Randall White was a judge for a long time. So Miss Wise has been around a long time.
And the role of the clerk in the courtroom during something like this is what?
Everything. I mean,
Okay.
well, on something like that, so the clerk will catalog exhibits, the clerk would help the judge, but on a regular docket, the clerk has all the files, passes the files up to the judge signs what the judge needs to, and then passes it, so the clerk is really the kind of, I can tell you this, on a regular docket, if the clerk is not in there, the judge can't do anything.
Gotcha.
Gotta have the clerk.
She does a lot of that administrative behind the scenes.
Scheduler, she's the scheduler.
Yep.
Except for the trial, then the judge calls the schedule on that. But as far as scheduling motions and scheduling those kinds of requests or sentencing hearings, then that the clerk does that.
Let's see what she's saying, if we can hear.
Okay, you took Mr. Mo.
I think they're just waiting for the defendants and the jury.
Bring out the parties. Yes, bring Dr. Warren back up here.
Yep.
Which I'm always afraid to ask y'all that, because every time I ask y'all have something I need to address. Y'all tell me something I need to address. Okay. You need some water?
I am going to get some. Thank you, Your Honor.
All right.
Okay, we may all be seated. Let the record reflect that the jury hearing the trial are back in the court after lunch, and I believe that before lunch, counsel for Mr. Hill, concluded your direct examination of Dr. Warren, and I believe that Mr. Montalvo, you did not have cross.
I do not, Your Honor.
Okay, is the state prepared to cross Dr. Warren?
I'll make that always fatal remark of I'll only have a few questions, and I'll be brief. All of those things that never come true. Dr. Warren, during your time with the TBI, you're a salaried employee, correct?
That is correct, yes.
And you were paid no differently for your lab work than you would be for your testimony, correct?
That is correct, yes.
All right. And just to be clear, you were retained by the defense in this case, correct?
Yes, that is correct.
Although you'll be paid through the administrative office of the courts on a set formula they've established.
That is correct, yes.
Which is lower than it ought to be. I'm sure you would agree, right?
I would agree with that, yes.
But in the position you are now, you are compensated additionally for your testimony time, correct?
That is correct. Any time that I'm involved in the case would be compensated, yes.
Okay, and that's fine. In this particular case, you've reviewed records, and records alone, correct?
That is correct. If by records you mean documents, that is correct.
So, if I were to ask that the Springfield XD9 exhibit be handed to you, that would be the first time you've ever touched it, right?
This particular one, that would be correct.
Okay. But you are familiar with Springfield XD9 semi-automatic handguns, correct?
Yes, I am.
Right. And correct me if I am wrong, but it holds 16 in the magazine with the potential to take the magazine out, put one in the chamber, take the magazine out, so you could have a total capacity of 17 rounds. Is that correct?
That is correct. That was what was measured by the Metro Nashville Crime Lab for this firearm.
Okay. And thus far, you've really had no disagreement with any of the findings that they've made, correct?
That is correct.
All right. So that's one reason this may go a little bit quicker. But with respect to, we keep talking about 6 shots. Say we, that seems to come out. We don't know how many shots were fired, do we?
That is correct. We would only have the 6 shots into the vehicle that we were discussing today.
So there are 6 strikes.
6 defects, yes, that is
Defects.
correct. Strikes would work.
And with respect to, you said how quickly a Springfield XD9 could be fired by someone who's trying to fire it quickly, depending upon their expertise, things of that nature. How slowly could someone fire an Springfield XD9?
Sure. So the speed at which, if we're talking about the maximum for slowness, what's the maximum amount of time, would be a matter of the maximum time available to that person.
Right. Of the brain sending the neuron to the finger to pull the trigger. It could be a pause, correct?
Yes, if that time is available, it could be.
All right. And in this particular case, you're estimating the time based upon the distances that we know, the times that we know, and the speed of Ms. Kaufman's vehicle, correct?
Yes, that is partly correct, yes.
And we do not know the speed of the Cadillac at any period from Hermitage, Tennessee to when it was burned in the alley, do we?
That is correct. I do not have any information regarding the speed of the Cadillac.
Okay. And it's possible, is it not, Dr. Warren, that that Cadillac could have had infotainment center or data that could be recovered to show that speed, that mileage?
Sure. I'm not familiar with the Cadillac, that particular make and model, but being a newer vehicle, I would expect that type of information to be present, yes.
Okay. So that evidence is gone if it ever existed.
None was, sorry, go
I said
ahead.
it went up in smoke when the Cadillac was burned.
There was none of that that was provided to me, nothing that I saw during the discovery.
Right. And with respect to, again, going back to that speed reference, your assessment is that the cars at whatever speed were parallel to one another. That's from the cones and the trajectory of the defects, correct?
Yes, if just to clarify, that the car that the shooting would come from would be on the driver's side
Exactly.
of the Mazda. That is correct.
Yes, yes. And for whatever period of time, assuming that the Cadillac was approaching and passing the Mazda, they would have been parallel, side by side, for at least a brief period of time, correct?
That is correct, yes.
And again, that would depend upon the speed of the Cadillac.
The speed of both vehicles and then also the rates of acceleration and deceleration.
Exactly, and what I said earlier is we know the speed of the Mazda. We know the speed of Ms. Kaufman's vehicle.
That is correct, yes.
So just talking about the speed of the Cadillac, that would be controlled by the driver, correct?
Yes, that would be.
Now, in this particular case, the time frame can't be ascertained exactly, can it? Because there is no data about the speed of the Cadillac.
That is correct. We cannot calculate the exact time.
And if your assessment, and I'm not disagreeing, that the first shot was towards the rear of the Mazda. It worked from back to front of the Mazda, correct? That's what you're
Yes,
told
that-
us, that in your opinion,
That is correct, yes.
that there is no evidence whatsoever that at any time the driver of the Cadillac veered, slowed up, did anything to alter those those trajectories.
So yes, that is correct. If I understand what you're asking, there's no information again regarding the speed of the Cadillac or the directionality.
And every shot went in, the Cadillac was in the same or very close proximity that it was from the first defect to the last defect, correct?
I would disagree with that. I guess it depends on how broadly you're talking about the proximity. So from the distance from the rearmost defect 1 to defect 6 is about 9 feet, again, laterally down the side of that vehicle. But in addition to that, you've got trajectories, the first and last, pointing farther away. So proximity in that it was on the driver's side, yes. Proximity alongside of the vehicle, no. There was movement that changed there.
Certainly, because they were going different speeds.
That is correct.
But there is no dramatic, as if the driver of the Cadillac did a 90-degree turn or did anything to dramatically veer away from his path of travel, correct?
Sure. So that would not be something that you can determine from those trajectories, simply because there's too many points missing. Again, if we knew a location or a speed, then we could potentially answer the question of was there a veering or a movement out of that lane. But in the absence of that, that's not something that can be determined.
But there is nothing to indicate that there was any braking, any gross deviation by the driver of the Cadillac in between defect 1 and defect 6. Would you agree?
Yes, I would agree with that.
And as you said, the cartridge casings were fired through this particular Springfield XD9. You have no reason to disagree with Ms. Whitaker.
That is correct. I do not have a reason to disagree.
And were you here in the courtroom or listening to Mr. Hill's testimony?
No, I was not.
Okay. These surveys, studies, have you yourself done an exercise in how fast you could pull the trigger on a Springfield XD9?
So I have not done any tests on how fast I can pull a trigger on a specific XD9. I am a long-time shooter, so I do know that I have done some rapid-fire tests, but not timing them and not specifically with an XD.
Mm-hmm. And in the course of the studies, that really is the point, is studying how quickly can someone do that.
Yes, that would be the point of that study.
Whole point. And as far as any studies dealing with the type of actual occurrence that we are dealing with in this case, there are no studies.
That is correct. There are no studies dealing with shooting at an occupied vehicle on an interstate. That is one of the advantages of scholarly peer-reviewed research, is if the correct variables are taken into account, as in this case, you can extrapolate or apply that data to a different scenario.
Yes, because it would be not only unprofessional, but dangerous to attempt such an example, correct?
Potentially, yes.
I don't know if that's as brief as I promise, but it's as brief as I can do. No further questions.
Okay, is there anything you redirect?
No, ma'am.
Okay, thank you, Dr. Warren. Watch your step as you're stepping down, please.
Thank you, Your Honor.
Okay, unless anybody intends to recall Dr. Warren, I'm going to release him from his subpoena. Release from your subpoena. Okay. Any additional proof from, on behalf of Mr.
No, Your Honor, that was Mr. Hill's proof.
Okay, I believe that Mr. Calvin. Correct, Mr. Munkabo. Okay. I guess the state needs some time to discuss.
Your Honor, if we have a rebuttal proof, it would be very, very brief, and we might not end up having any, but if we could just.
Okay.
We're breaking
Ladies and gentlemen, I think that's going to do it for us today. We have a lot of things. As I told you, sometimes we have to work out some things among us that don't concern you. So going to release you today. Thank y'all for coming in on a Saturday and giving us your time this Saturday morning. Now, we'll be back on Monday. I'm going to let you sleep 30 minutes longer. So I'm not going to start at 8:30. We're going to start at 9 on Monday, okay? Let you sleep a little longer. Mr. Fox and Miss Adams will get some instructions from you, or to you. Thank you. Now, don't discuss the case among yourselves or with anyone, or do any outside research. Thank you. Okay, we may be seated. I think that Ms. Franklin is going, she's made the adjustments to the jury charge. I think she's going to email them to you if y'all want to look over them again, and if you have any questions or suggested edits, just let us know in that regards. And the state, I know that you have to, I guess, think about what you're going to do, but I guess so we'll, if the state does your rebuttal, you said it'll be brief, so on Monday we'll be prepared with your closing arguments, and then we'll go into the jury charge on Monday morning, okay? Anything else? Yes, sir.
I may have missed this, 8:30 again?
Yes, Mr. Chaffin. No, 9 o'clock. 8:50, y'all be here at y'all be here at 8:50 so that we can start at 9, please.
I'd like to notice that I've been here early every day.
Yes, sir. All right. Okay, I'll see y'all next week, I guess.
All right. Thank you.
Uh-huh.
All right, that is a wrap for this Saturday. The judge had said she would probably let them go early. I think she was hoping they'd finish the defense's proof, and that's it. The defense basically just calling 2 people, wrapping it up. And so when we come back with you on Monday, they'll start things off, Nick, with what?
Well, they'll start things off to see if the state has any rebuttal proof, and that would be, are they going to call, the state's already rested, but if something has come up that the state had no idea that was going to occur, somebody was going to say something they had no idea, that they could have a rebuttal witness.
Maybe Gish, someone, or maybe one of their witnesses.
The times that we've seen this before is where somebody testified that they were not there, or let's say rather they testified they were at the scene of the crime, or they were somewhere and they witnessed a certain thing. And then I remember once we had a sheriff's deputy come in there and say, no, Nick Barris was in jail that day.
Yep.
So those kinds of quick rebuttal witnesses. Then they will go into the closing arguments. As the state has a burden of proof, so they'll go first. Then we'll hear 2 defense closing arguments, and then the state will get the final word. And then poor Judge Dalton's got to read that 60-page document.
That's a long
cure for
jury
insomnia.
charge. Yeah.
And then she sends them on their way to begin deliberations.
Likely jury deliberations will probably begin after lunch on Monday. And I'm thinking we'll have a verdict before the evening in this.
And I will say the defense is very, very fortunate, because I would not want the jury to go into deliberations after hearing Hill's testimony today.
Yes,
I want that to...
And I'm just wondering, as we kind of wrap up our coverage here, she says, go home. So this is an unusual one where you have a Sunday where nothing's going on and they're going to come back and just start deliberating on Monday. What are the odds of them not researching the story or talking about it with any family members on Sunday, the jury?
Well, so I don't know that there's any real bombshells that we've talked about that the jury doesn't know. And one of the biggest ones.
No, I mean, they get home and one of their children says, "Hey, how's the trial been?" and things like that.
I watched it on TV.
Yeah,
I saw him testify. Everybody is tuning in. All the wives, all the kids, everyone is tuning into that trial. And so you could only hope that, everyone would, but you only hope that they don't talk about it. But it's not as, everyone knows first-degree murder, it's life in jail. They've already admitted they're in jail.
Yeah.
They've already admitted they're in jail. It's not so, so important as it would be, let's say if they were like a Vanderbilt rape case and they weren't sure what some of these penalties were, you know? And I think that would be a whole lot more significant. But the one thing that we heard about that I thought would, could really change things actually came into evidence. So
that's it. So listen, it's been a long week, and what we're going to do is, I know so many people have thoughts, questions, and comments. We're going to wrap things up too. I mean, she ended early. The jury's going home. The lawyers are going home. We're going to go home, but we'll be back for sure on Monday. And keep in mind, Monday, especially once jury jury begins deliberations, we'll be sitting there taking calls and comments for however long it takes for that verdict to be returned. And we'll kind of recap the trial and the high points and low points of it. So we'll have all of that. Of course, if you're interested, you can message me on Facebook at Nick Barris NC5. I'll try to answer your questions there. But Nick Leonardo and I will be back on Monday. Enjoy the rest of today. I hear it's nice and sunny outside. We haven't seen much outside over the last 5 days.
It's like a casino in here.
Yes, it is. No windows. And then tomorrow as well. But we'll be back. Our gavel-to-gavel coverage of the Caitlyn Kaufman trial continuing. And we expect it to conclude on Monday. You want to be here for that. For Nick Leonardo, I'm Nick Barris. Have a great rest of the weekend, everyone. And we'll see you back here on Monday. Bye-bye.